Good afternoon and welcome to the Appellate Division First Department. Nice to see everybody here. We do have about 6 hours of argument time that's requested, so we would ask you to please just ask for the time you really think you would need to hone in on the important issues. I know you are aware of the fact that we have had your briefs and your records and we are familiar with the cases, so we just want to get to the important parts. You'll remember that when the white light goes on, that means you have 2 more minutes. And when the red light goes on, that means you should be finishing up your sentence or just finishing answering a question. If we have additional questions, we will continue on. Okay, so let's call the calendar. First case, and then counsel, please stand up and you'll let me know how much time you're requesting. First case is People versus Russell West.
Good afternoon, Your Honor. Appellant requests 6 and 2, please. Good afternoon. People request 6 minutes, please.
We're going to do 5 and 2 and 5. Thank you. Bialucha versus City of New York. Is the respondent here? Now, the respondent's also a cross appellant. They're not here? No? Oh, okay. So, do you want to argue for a few minutes or do you want to just submit? Okay, so we'll give you 3 minutes and the other side. Okay. The next case is P. Mariah, and that case is submitted. Lopez versus 106 LPA. Appellant? Okay, well, that's like the maximum you asked for, so that's what I said you shouldn't ask for, but okay. Who's the, and we have the plaintiff is cross appealing?
Respondent, appellant, 8 and 2.
And who's the other respondent? Okay, so I'm going to give you 5 and 2 for the appellant, and 5 and 2 for the cross respondent, and 3 for you. Thank you. Eliako versus Reardon. That case is submitted. People versus Michael Key.
4 and 1, please.
4 and 1 for the appellant and for respondent.
4.
Okay, 4, 1, and 4. Century 21 Department Stores versus Star Surplus.
Good afternoon, Your Honor. For the appellant, 8 and 5 requested.
Now, I have 3 defendants here. Are you all planning to argue?
I'm the appellant.
I mean, 3 respondents here is what I'm saying.
I'm not responding.
I understand. You're the appellant. I heard you. Now I'm saying I understand there are 3 respondents here. And are you all planning to ask for time?
No, Your Honor, I'm here to introduce, I'm Siobhan Gandhi, here to introduce my brother,
And what firm are you from?
Robinson Cole.
Okay. So how much time?
We would ask for 6 minutes.
Okay, and who are you?
Responded for access, we would request 5 minutes.
And okay, and you're the appellant. Okay, so we're going to give you 6 and 3 for the appellant, 6 for you, and 5 for you. Okay. Hassin versus Hassin.
Good afternoon, Your Appellant. For appellants, 5 and 2, Your Honor.
Okay. Respond.
Respondents, 5 and 2, Your Honor.
Okay, 5, 2, and 5. Frid versus McDonald.
Good afternoon, Jacques Simon for the appellant, requesting 7 and 3.
And respondent? I'm going to give you 5, 2, and 5. Thank you. Gilbane Building versus Fort Hill Construction.
Appellant, good afternoon, Your Honor.
Good afternoon.
Requesting 5 and 1.
Okay. And respondent?
Respondent requesting 5.
Okay. 5, 1, and 5. R. Kalia versus Evans is submitted. People versus James.
Appellant requests 5 and 1.
Okay, 5, 1, and 3. Samasiros versus New York City Department of Buildings. Probably got that wrong anyway, but tried.
Good afternoon, Your Honor. For appellant,
And respondent?
I responded 6.
Okay, I'll give you 6 and 2 and 5. Thank you. Pereira versus KSK Construction.
Appellate request 5 and 1.
Okay, thank you. And,
KSK Construction, that requests 4.
okay, and there is another respondent? So there is. They said they were coming? Well, you know, things change. All right, I'll give you 5 and 1. I'll give you 4. If they show up before we finish the calendar, we'll deal with it. Okay, thank you, Candace. People versus Reese. Good afternoon. Okay, and respondent? Okay, well, I'll give you 6 and 2 and 6. If we have additional questions, we'll keep you going. 1643 First LLC versus 1645 First Avenue. Okay, and respondent? You got it, 5, 2, and 5. And the last case is Newell versus the City of New York, and that case is submitted. We do have a young barrister here from England to observe our proceedings, so we had a chance to meet with her, and so I'm sure you'll all be on your best behavior anyway, but we wanted to let you know we have a guest here. Okay, first case for oral argument is People versus Russell West. Good afternoon.
Good afternoon, Your Honors. May it please the Court. Aviva Galpert for Mr. Russell West. Mr. West's SORA level is invalid because of the failures of process here, where Mr. West was not present for the full hearing below, and at that hearing, the Court failed to conduct the analysis mandated by the Court of Appeals. Remand is necessary so that Mr. West can receive a proper hearing. Had the appropriate procedures been followed here, Mr.
Also, did
West...
the defendant object?
Your Honor, he did not object, but he did repeatedly invoke his affirmative desire to be present. He did not waive his right to be present.
And he wasn't he? I mean, my understanding of the record is that when the feed went down, the court was notified that the feed went down. The court stopped the proceeding, ensured that the defendant was back on before proceeding with the hearing. Defendant's present.
Your Honor, what we know for a fact is that Mr. West was wholly absent for at least some of the hearing. As you said, the feed went down. We have no idea what the limits...
And at that point, the hearing was stopped, correct?
Your Honor, there's no way to know that the hearing was stopped as soon as the feed was lost. And it was not the entire feed, it was just Mr. West's connection. There's absolutely no way to tell how long he was gone. The prosecution would have you believe that the clerk noticed immediately, but that's simply not true. The court didn't ask Mr. West whether he was able to hear...
Well, do you have any indication if the clerk didn't notice immediately?
Well, Your Honor, I believe what we have here is affirmative indicia in the record that Mr. West was gone for some portion of the proceedings.
That's
So
undisputed,
be-
but it's
yes.
also the record that the court stopped, waited for the feed to come back before proceeding.
And then
That's
didn't
correct.
the court indicate on the record that they saw the defendant present at that point, and then they continued?
Yes, Your Honor, there's no question that Mr. West was virtually present after the feed was brought back. What we don't know is how long
So
he
you're
was
saying
absent.
he may have missed things and nobody may have realized that.
Exactly, Your
That's
Honor.
what you're saying?
Exactly. And you
But
know,
the court,
furthermore-
in fact, stated, when the clerk says we lost the defendant, the court says, I say that we will suspend for a moment.
Yes, Your Honor, that's true. It was eventually noticed that Mr. West's connection had been lost, but it may have been lost well before it was noticed by the clerk. We don't know whether or not that's true. And even if he were present the entire time, we submit that it was actually not a meaningful presence. He wasn't able to consult with counsel privately. He wasn't able to, interrupt the proceedings.
What has this court held in terms of the virtual proceedings that happened during COVID? I mean, this is not the only one. There were several. What's our policy? What does our law say about that?
That's correct, Your Honor. I don't believe there is a statement of law about that. We do believe that there may be virtual proceedings that would be adequate. For instance, if the court, first of all, elicited a valid waiver of the right to physical presence, or if the defendant were given the opportunity to consult privately with counsel, or were even notified that he could interject to make corrections. For instance, here, there was a significant error that went uncorrected, and that's the fact that Mr. West received a perfect score on not just his last, but his last 2 sex offender treatment and counseling
So now you're
programs.
moving into a different area of your argument. That doesn't really have anything to do with the remote.
Well, it
COVID.
does, Your Honor, in that if Mr. West had been present, he might have been able to say, actually, it was 2 evaluations on which I received a perfect score.
What prevented him from saying that in this remote setting?
Well, it's much more disruptive to interrupt a Zoom call, whereas if he had been there in person, he could have sort of
An
privately
interruption
nudged
is
counsel.
disruptive, whether it's in person or Zoom.
Well, that may be, Your Honor. I believe that it's somewhat qualitatively different, but the fact of the matter is that had the appropriate procedures been followed and had all of the mitigators been considered and all of the evidence of the mitigators been appreciated by the court, Mr. West, who is an elderly, devout Muslim man who graduated from college with honors during his 4 decades in
Well,
prison.
counsel, if I may, was there any indication that he was unable to hear what was going on? He could not communicate with his attorney, anything like that?
Well, all we know about what he was able to hear is that after the connection was lost, when he was brought back on, he could hear the court when the court said, Mr. West, can you hear me? That's the only time during the entire proceeding he was addressed directly. That's the only time any effort was made to ascertain what he was perceiving on his end of the line.
Right, but nowhere in the record does he say, I didn't hear what was going on, I wasn't able to participate, I wasn't able to connect with my attorney. We don't have that anywhere in the record.
That's true, Your Honor, but this was a mode of proceedings error, and even if this court disagrees, it may reach this issue in the interest of justice, and we believe that's appropriate here. Again, there were egregious failures of process below. It's understandable this is a chaotic time given the pandemic, but...
And I do believe that in 2022, this court, in fact, did issue a decision that said that that's proper for the court to hold these kind of, due to the pandemic, to hold certain proceedings remotely. Just so that we're clear on that.
Thank you, Your Honor.
And this was particularly early along in the pandemic. This was just in the summer of 2020 when we were kind of beginning with those hearings, but he did indicate that he wanted to go on with the hearing and there was communication. All right, let's hear from the other side. You'll have a few minutes in rebuttal. Thank you.
Thank you, Your Honor.
Thank you. Okay.
Good afternoon, may it please the court. Megan McLaughlin for the people.
Counsel, how do you respond to your adversary's position or contention that we just don't know how long the defendant was disconnected?
Well, my response to that contention would be that, first of all, there's a very, very good indication that it was mere seconds, and the court specifically requested that the proceedings halt until the defendant was back. The transcript.
What indicates to you that it was just mere seconds? Because all we have is I think, an officer saying connection has been lost or something to that effect. The court saying, let's hold on. But what is there to indicate whether he had been disconnected a few minutes, 10 minutes, half an hour?
So the clerk interrupting the proceedings to say that we have lost defendant was an indication that it had just happened, and then the judge answering, quote, I see that, was an indication that this was a contemporaneous observance of what happened.
Do you know how far into the hearing this first notification of the loss of the connection was?
Yes, this was about halfway through, but I do believe the important issue here is not whether there's sufficient evidence of the fact that the amount of time that this drop occurred, which is seemingly very small, but the defendant has the burden to present evidence, a substantial amount of evidence, that the defendant did miss a meaningful amount of this hearing, and the defendant has clearly not presented any evidence whatsoever. In fact, something that the defendant could have easily done when welcomed back to the hearing after this short drop was, I didn't hear anything. The defendant was presented by counsel at this hearing. The counsel could have said, hold on, Your Honor, I don't know how long the defendant has been missing now. Can we recap that? None of that happened, and that's another indication that this happened contemporaneously with the drop. Is
there a process for the defendant to speak with his attorneys privately?
Yes, so the hearing was actually adjourned twice, specifically because the defense counsel had requested more time to speak with the defendant privately. Also, during one of the colloquies in which this defendant consented to proceeding virtually, the court specifically asked the defendant, have you had enough time to discuss this with your attorney? And he said yes.
One of the things that your adversary raises is that even in light of all of those things, in our interest of justice powers, then we should proceed the way that your adversary wishes us to proceed. What's your response to that?
My answer to that is that this is not a case where that is warranted. To answer Your Honor's question to my adversary, this court has in fact found that let me actually just quote it, the court has the authority to modify its hearing procedures and move forward with conducting a hearing virtually, citing judiciary law. That case was Joshua A. This court found this decision in 2022. The site is 202 AD 3rd 507. And this court found that this was a proper decision for the court to have made. The defendant then consented to proceeding virtually multiple times. The case was adjourned multiple times in order to ensure that the defendant had enough time to discuss.
So before your time runs out, do you want to speak at all to the merits? I mean, I know you think we shouldn't reach them, but in the event we were in the interest of justice, do you want to address the merits of their claim?
Yes, about the
downward departure?
Yes, Your Honor. The defendant has failed completely to establish that this defendant presents anything other than a high risk of reoffending, as he similarly failed to do below.
What about their claim that his participation in the program was exceptional?
That is simply not established here, Your Honor. The defendant presented evidence that he completed sex offender treatment in line with any other. There was no evidence that this defendant did anything more exceptional than what he would have had to do to complete the program, and he was given credit for that under Factor 12, where he received 0 points for having taken responsibility for his crimes, notwithstanding the fact that there was actually multiple indications during this exact treatment that indicated that he hadn't actually taken full responsibility for all 10 stranger sexual attacks that he had committed throughout.
Didn't the people ask for 15 more points based on that, based on him admitting drug use, and didn't the court deny it?
Based on the drug use, yeah. So the people had no reason to believe up until the defendant's submission that he had struggled with substance abuse in the past. However, the defendant submitted 2 days before the hearing a written submission indicating that partially his crimes had been motivated by substance abuse issues. So the people acknowledged at the hearing that their notice requirement would have required them to ask for those points before the 2 days that the defendant had notified them of that claim. But in any event, in general, the lack of exceptional response to treatment and the lack of genuine acceptance of responsibility here was more than taken into account enough by the lack of points under Factor 12. Thank you.
Okay, thank you.
Your Honors, first I'd like to briefly note that Mr. West was not given a choice not to proceed with the hearing at the time it occurred. There were adjournments previously so that he could speak with counsel, but he had no opportunity to speak with counsel privately during the hearing, and he was not told that the hearing could be further adjourned so that he could ultimately proceed in person.
Well, it would have been a while, and he would have had to stay incarcerated during that time, correct?
Well, a provisional order could have been issued, but either way, that was his decision to make, and he wasn't given the opportunity to make it. But I'd also like to note that nothing keeps this court from addressing the downward departure argument. The people do not argue that that was unpreserved.
Well, I mean, I do note 2 things, that in the many SORA hearings we have seen, I don't recall any SORA hearing where anyone was ever assigned 155 points. So that was about the highest level I've ever seen. And also because of the situation with your client, with your client, most of his life he had been incarcerated for a very, very long time. So his ability to function outside has really not been established, even though he is somewhat older at this point.
Well, Your Honors, so the presumptive level does account for the points, but that's why we have the downward departure as a mechanism to account for extraordinary factors like we have in this case. Again, he's 70 years old. When the offenses occurred, he was a young man with his own untreated sexual trauma.
Just be careful what you say about those things.
Well, I only mean that to say, Your Honor, that a significant amount of time had passed since the offenses were committed. He spent 4 decades in prison, and you're right, he didn't have the opportunity to show how he would fare outside of prison, but he did
Counsel,
show...
when we're talking about assessing the potential risk, right, I think it's fair to say that he was assessed 30 points on the factor 3, right? But that involves three victims. Here there were 5. So there's a strong argument to be made that he was underassessed.
Well, Your Honor, we believe, again, the fact of the matter is that his risk is best understood by looking at who he is now at 70 and not who he was at the time of the offenses, not the nature of the offenses themselves. And furthermore, the court erred as a matter of law in denying the downward departure, not because of the totality of the circumstances, but because it did not even consider a number of the mitigators presented. And there was a significant misapprehension of fact with respect to the one mitigator that the court actually did consider on the record. And so this court cannot assess whether the lower court conducted the Gelati analysis properly.
Okay, thank you.
Thank you, Your Honors.
both. The next case is Bialucha. Good afternoon.
Good afternoon. May it please the court, Michael Taub, the Plata Law Firm for the plaintiff appellant Pavel Bialucha. The reason why the lower court was incorrect is that the plaintiff proved prima facie entitlement to summary judgment. His conduct was not and could not have been the sole proximate cause of the accident, and the defendant did not and could not prove that Pavel Bialucha was a recalcitrant worker, and therefore the plaintiff was entitled to summary judgment.
The plaintiff assembled the scaffold in this?
I'm sorry, Your Honor?
Did the plaintiff assemble the scaffold in this instance?
The plaintiff did not assemble the scaffold. The
But
scaffold,
he did check it out before it went up to the 5th floor, correct?
that is not indicated specifically in the record. There is a question in the record as to whether the plaintiff put in the pins, whether his coworker, Mr. Staniewski, put in the pins.
What we do know, counsel, is that he was working on that scaffold for several hours before it collapsed.
He was working on the scaffold for 3 hours before it collapsed. It was actually almost 3 hours, maybe not quite, but it was almost 3 hours before it collapsed.
And then the
That is
platform just fell down like this.
It went down straight. So that is the contention, that when a scaffold collapses for no apparent reason, and there was no reason ever indicated here, the plaintiff is entitled to summary judgment under those facts. The fact that the record does not indicate that Mr. Bialucha was the one who put the pins in.
I
is why
thought
the
on the
Blake-
record, page 160, the plaintiff testified that he was the person who constructed the scaffold. Maybe, is
Can I
that,
get Your Honor's question again, please?
record page 160?
Got it.
I could be mistaken, but I thought I read that he testified that he constructed the scaffold.
Page 160, Your Honor, I'm sorry, appears to be a bill of particulars, but in any event, I don't think it's in the record at all that he assembled the scaffold. I'm sorry to...
No, I mean, I read the deposition. Maybe I read it wrong. I don't know. I'll read it again. How about that?
It might be in a deposition, but to the best of my knowledge, the record's going to say what it says. To the best of my knowledge, the plaintiff did not construct that scaffold. There is a question as to whether the plaintiff put in the pins. He said they. Mr. Staniewski, at one point, well, he was very equivocal in his testimony as to who did what. The other thing is that it's not even indicated if Mr. Bialucha did put in a pin, what pin he put in. There were 2 pins. There was one on one side and one on the other side. It's not even indicated which pin malfunctioned, if you will, if in fact a pin did malfunction, because that's also not in the record. The testimony of each of these gentlemen, Mr. Bialuka and Mr. Staniewski, who, by the way, did not witness the accident. Oh, I see that my red light is on. I don't know.
Just finish your
Okay.
thought.
Who did not witness the accident, his testimony was also equivocal. While my red light is on, I would also attempt to impress upon the court that this case is on all fours with this court's Perazo case from 2022. Obviously, the defendant is going to go about and try and distinguish it. That's what you have to do in a summary judgment motion, but the case is on all fours. So I would end with this note to the panel. The plaintiff was entitled to summary judgment. If there is a question of fact so that that summary judgment motion is denied, the defendant's cross motion for summary judgment must also be denied. And I would thank you for your time.
Okay, thank you very much, counsel. The next case is Lopez. Good afternoon.
Good afternoon. May I please the court? My name is Beth Seidak. I'm with the law offices of Litchfield Cabo, and we represent defendants, appellants, and respondents in the case 106 LPA LLC and Layani Development Group LLC. We submit that the court below erred in denying that portion of our motion for summary judgment that sought the dismissal of plaintiff's labor law section 240, subsection 1, cause of action. Based on the evidence in this case, as well as the applicable case law, we believe that we are entitled to summary judgment on.
The lower court concluded that there was an issue of fact. Why is the lower court wrong?
I submit that based on the very recent on the recent decision earlier this year, Connor v. AMA Consulting Engineers, which is identical to our case, to the case at bar, we are entitled to.
Oh, now, we are familiar with the Connor case, and we know about that. So that was where a piece of sheetrock, at least from the decision, partially fell, and there was a question about that. But it did make reference to some of our other cases where there was more than one piece of sheetrock, and that fell, and there were questions of fact. And in this particular case, it was a concrete form that fell. The testimony, which I believe was unrebutted, said it was approximately 50 pounds, and it fell down on the plaintiff and injured him. So why isn't there at least an issue of fact as to whether it was foreseeable that leaning that type of a structure up against the wall where people were working might not fall and injure one of the workers?
We believe that the facts of our case are identical to the facts in Connor's in terms of this form, the concrete form. The concrete form was weighed on the same was 50 pounds, which is the same, approximately the same weight of the sheetrock that fell on in the Connor case, on plaintiff in the Connor case. Also, the measurements, as the court pointed in Connor, 8 feet tall and 4 feet wide, are the same.
Counsel,
sorry.
So I understand the Connor case and how it distinguishes itself from the Padilla and the Cuyon case, which is really the controlling law coming out of this department, where we're talking about gravity. We're not really talking about weight and height, and maybe this case distinguishes it, but where there's a gravity-related incident, why doesn't that invoke 240 sub 1? regardless, I mean, 50 pounds to one person is 50 pounds to another, is different to another person. Why is that the litmus test? It's the gravity that's the issue.
Well, in this case as well, the concrete form that fell on plaintiff, also the top portion of the concrete form fell on plaintiff, and the gravity would be basically the same, or the force of the gravity would be the same as in the Connor case, where the weight, where almost the weight of the weight of the sheetrock and the weight of the concrete form were almost identical, and the measurements would generate the same force.
Well, we're assuming that, right? Because that is one of the differences between Connor and this case. In Connor, you had an expert that testified about the strike force of the falling sheetrock. Here, we don't have that, correct?
Correct, we don't have an expert.
Anything else you'd like to address, or you want to wait till your rebuttal?
As with respect to the section 241.6, we submit that the court below correctly dismissed this cause of action, and finding that all industrial code provisions that plaintiff...
Well, counsel, it seems to me, after looking at the reply brief, that there is really one industrial code section that the plaintiff is relying on, and why is that one section not applicable here?
Does Your Honor refer to section...
23-2.2D, I believe, is the one section.
That's right. We submit that the court below correctly relied on the Cody case, finding that plaintiff did not provide sufficient evidence that the form came from stripping. And similarly, in this case, the lower court found that plaintiff provided insufficient evidence that the form came from stripping, and we rely on the record. Plaintiff was not involved in the prior work that involved the concrete form. When asked if he know who placed the form, he said that he did not know who placed the form in the garage. Also, plaintiff testified that he didn't know where the form was placed in the garage. So the fact patterns, the testimony is almost exactly the same, and the evidence is insufficient to show that the form came from stripping.
Counsel, if I may, I know that you are relying on Connor. You take the position that it's controlling. I sat on that case, but since you say that there's no expert testimony, I mean, you just acknowledged that from my colleague regarding the striking of the force, it's not really applicable here, correct?
Well, in this case, we relied on the Cody case, and the court actually found. I don't think so. I don't think there was an expert in that case, but the court in Cody relied solely on the testimony of the plaintiff.
I see.
On the plaintiff. In our case, the same thing. The court found that that there was insufficient evidence that this particular form came from stripping. Plaintiff just couldn't say either way that who placed the form.
Okay, counsel, I'm going to let you.
Was placed.
All right, you'll have a few minutes on rebuttal, okay? The plaintiff, you're also a cross appellant?
Yes.
Yes, okay.
Good afternoon, Your Honors. I'm Martin Moskowitz on behalf of Gorieb and Associates and the plaintiff respondent appellant Gerson Lopez.
So, counsel, when the court below decided this case, the Connor decision hadn't been issued yet, and maybe Connor seems to, I guess, issue a little bit of more restriction on this, how we should interpret this gravity force, and we're going to look at things such as the amount of distance it had to travel, the fact that they were maybe not as heavy as other items that could fall on someone on a construction site. Is that the approach we should take in this case, and if so, why not? Or if so, why?
Well, Your Honor, In this case, we're talking about forms that retain concrete, and these forms are built by carpenters, and my client's a carpenter. And the Board of Labor, recognizing the dangers and weights, and I understand there are different size forms, but recognizing the dangers involved with forms, actually passed industrial code rules when the forms are being attached for the concrete pours.
But are we
and when
talking
they're
about
being
industrial
stripped.
code rules when we're talking about 240 sub 1, or is that a different?
Well, what I'm saying, Your Honor, there's a recognition of the danger of these forms, their weight and the damage that they could do.
So you're saying this is the type of activity that the labor law 240 subsection 1 would be concerned about as well?
Yes, and in this case, my client is placing a vertical post on the ground, and the form falls over onto his back. He's pinned to the ground, falls to the ground, he screams, his colleague lifts it off of him, and there is only attorneys here talking about the amount of force that is. But there are no experts, and it is for a finder of fact, a jury, to determine the amount of force, and in that way, the judge has it correct. And he cited to cases from this department in 2022 where things tilted over, and you can argue, well, that's more weight or less weight or whatever, but you're talking about a three-dimensional form. You're not talking about a thin board. It's metal, it's wood, it has concrete stuck to it, and that's my segue into the 241-6. The Cody case talked about a plaintiff who fell because of a piece of wood that he speculates may have been from a form, but he doesn't know. My client's a form worker, he's a carpenter. He was asked, what was it that fell on you? He said there were 8 forms in the garage, 8 forms. Some were leaning, some were scattered. None of them were compliant with 2.2D, forms shall be promptly stockpiled or removed from the area in which workers, areas in which persons are required to work or pass. So they didn't do that. They didn't remove it.
How do you respond to your adversary's contention that the stripping aspect, the requirement of that particular industrial code was not met?
Well, my client was asked where these forms came from. Were they from the concrete work in the garage? He said yes. He said, did you do that work? He said, no, the work was done by the crew from my company that was working on the elevator shaft at the time. They were the ones who did it. He was asked if he knew when they did it, and he didn't know when they did it, but he knew they did the work. They didn't ask any further how he knew, but he knew. And he described it as a form, and the form had concrete on it. And the form only gets concrete on it. You build the form, and then you pour the concrete into the form, and so then you strip the form, and the residue of the concrete that stuck to the form, which he testified it was stuck to the form, shows this was from stripping.
Is it of any moment that your client was not involved in the stripping?
No, because the provision says it's to protect workers who are to work in the area or pass. They don't have to be part of that work. The whole idea of the labor law is to protect workers at construction sites who are exposed to hazards. Not
He was from the same company, but he was doing
They
different
are
work
the
at
same
moment.
company, and he's a carpenter, and he's part of the form work. And the thing about forms is they recycle them. You know, they don't take the form and after they used it, throw it out. They take it to the next place where they need to pour forms, and they use it again. His crew was removing wood supports, vertical supports, that was holding up the concrete ceiling of the garage that was still under construction. So this is not like they took the forms and they put it into a storage area and no one was going to work in the storage area. My client's group was sent to remove the supports for the concrete to bring it up to the 3rd floor to continue that work. So all of this is generated out of the fact that they're stripping forms, and they left these forms in a manner that is completely opposite of what's required by the code. And the fact that there might have been a little time difference.
So you're saying you at least raised issues of fact with the 240 subsection 1 as well as with the 241-6.
I think my client is entitled to summary judgment under
But you didn't-
241-6, but at the very least, there are issues of fact.
Okay, great. You'll have a couple of minutes on rebuttal. Counsel will hear from you.
Good afternoon. May it please the court, Allison Snyder with Barry McTiernan and Moore for the third-party defendant respondent Scalpel Contracting. I just wanted to address on the Labor Law 240 claim. The court below claimed that found that there was a question of fact whether or not the fall of the form was de minimis. That's not a question of fact. That's a legal determination whether the weight and size of the object is significant enough to constitute a significant elevation or if it should be subject to extraordinary protection.
Hasn't this court found before, because I think what you're talking about, where the court below cited to that, he relied on specific language from one of the decisions coming out of this court.
Yes.
And where we, in fact, said that was an issue of fact. So I'm a little bit confused about
well, I have to say, just I know that you were getting at the difference between gravity and the size and weight of an object, but the fact is that here, nobody's contesting what the size and weight of the object was. We know what it was. It was 50 pounds.
Well, we
It was
don't know
8
it's
feet
a
high.
strike force because there was no expert testimony.
Well, but there doesn't need to be expert testimony. The court can find on its own that 50 pounds falling is going to be significant or not. In Connor, there was actually a dispute about the weight of it, and the plaintiff's expert was the one who said it was 40 to 80 pounds. So even if you credit the plaintiff's expert in that case, this court...
Assuming that the strike force of a falling piece of what was it, sheetrock, will generate the same force as a falling piece of the form.
Well, there's certainly no. The testimony here was that it was a wood form. There's no testimony that there's any difference between. The court below, in Connor at least, said, look, even if we accept 80 pounds, any of the other cases that have found that a weight that a single piece, a single object is going to be significant enough to generate the force, they were citing cases that were 300 and 350 pounds. So it was even 4 times the greatest weight. And here we have a single form.
So then what you would like for this court to do is maybe issue some kind of bar that, well, if it's 50 pounds, that's not enough?
Well, no, I think there has to be consistency. Anyone looking at this court's decision in Connor can say, look, we know that a single sheetrock panel that was 8 feet tall, 2 feet wide, and weighing between 40 and 80 pounds, this court has said that's not going to be a weight that is going to, or an object that's going to generate significant force.
Well, I'll tell you, I was reading the Connor case, and it was a little confusing to me because it did say only a portion of that piece of sheetrock, which was of significant weight, tipped over. So I'm not even sure what that means. You asked for consistency. I don't think I've seen 2 Labor Law 240 subsection 1 cases that are the same in all my years. There's always some differences. So it's kind of, we try to create some kind of lines, but it is difficult.
I would just say that the facts are about as close as you can get. It was the same thing. I think Your Honor had asked about the difference between a single unsecured object. That's exactly what the sheetrock was in Connor. It was unsecured. It was vertical. It was a single object leaning against a column, and that's
and
what we
only
have
a
here.
portion of it fell on him, as opposed to.
Well, the plaintiff here doesn't know what portion of it fell on him either. He just knows that he was struck in the back. But we're talking about plaintiffs. I believe they were both under 5'6", so it's about as close as you're going to get. The only thing I just wanted to quickly say about the industrial code violation is that the plaintiff himself, when he's arguing about section 23 2.1A1 that refers to material piles, he's saying that there was a violation because the forms were stockpiled. But when it comes to an actual industrial code regulation that talks about stockpiling, he's saying that they weren't stockpiled, except that we know here that the actual forms, once they were removed, once they were stripped, they were placed in different portions. They were, to the extent that you could say stockpiled, they were placed either on the ground or they were placed against the wall, and that the plaintiff could easily pass. There's no dispute about that. He said that they could walk by without coming into contact with it. So you do have to give just a fair interpretation of the regulation. And the plaintiff isn't saying that his accident was caused because they weren't adequately stockpiled. They were stripped, removed, and then placed against a wall.
Okay,
Thank you.
Appellant, you have...
Your Honor, so we submit that, as my colleague argued further that our case is similar, the facts of the case are similar to the Cody case, and plaintiff was struck by a single object, which was a small concrete form that weighed the same as in the Connor case, for 50 pounds, approximately 50 pounds, and that the only portion of the form struck plaintiff, the top form. There is a testimony that the top portion, plaintiff testified that struck him, the same as in the Connor case, and the force would be the same. And with respect to the industrial code provision 241 2.2d, we submit that, again, there was no evidence that the forms were improperly stockpiled, and in any event that the provision is inapplicable. The plaintiff provided insufficient evidence that this form came from stripping, didn't know, was not involved in the stripping work with the prior crew, didn't know how long the form came. He was specifically asked when he came to the garage 2 weeks prior to the accident. You could not say either way whether the form was there or was not there, and who placed the form. There is a testimony in the record. Thank you.
Thank you. Counsel?
We're back to the fact that there's a want of proof here. There is no proof on force. They talk about what part of the form hit him. The top of the form, the weight of the form at full arc hit him in the lower back and covered his lower body from his back down to his feet. So the weight of the form landed on him. Stockpiling is a common construction term, and when you look at the maintenance cases, it's laying it flat in a pile where it won't tip over. This idea that they stockpiled it properly by leaning against the wall is a fiction, and there's no expert calling that stockpiling because it's not. My client was required to work in an area where they didn't properly remove the forms from the room or stockpile it, and it fell on him.
Thank you. Okay, thank you all. We will certainly take another look at this. The next case for argument is People versus Michael Key. Justice Rodriguez is recused from that case. Good afternoon.
Good afternoon, Your Honors. Nathan Brown on behalf of the appellant, Michael Key. This court should vacate the order of protection here because the lower court failed in its statutory obligation to state its basis for issuing the order on the record. The record is entirely clear that the court only ever stated that it was going to issue an order of protection and never why. And that failure is particularly glaring here, where there's no real indication that the order of protection would provide the type of protection contemplated by an order of protection. As I'm sure Your Honors are aware, the boilerplate form prohibits the contact at the protected party's home, place of employment, school, prohibits contact by phone, email, voicemail. None of this in the record, the record suggests that my client had no way of knowing any of that information, no way of knowing the complainant's home, his telephone, anything of that nature. And the only argument that my adversary raises to suggest that the court properly stated its basis is in fact a meaningless tautology that would completely eviscerate the statutory mandate contained in the CPL. This claim is not barred by an appeal waiver because every other appellate division has held that an appeal waiver does not encompass an order of protection, and this court should join its sister courts. On top of that, the appeal waiver here was invalid. The court presented the appeal waiver as a complete bar to appellate review, did not indicate any rights that survive, and generally the explanation was confusing, where the court should have taken a bit more care when my client here evinced some measure of confusion in the proceeding. There's multiple stages in the proceeding where he asks the court for clarification. The proceeding is paused so that his defense counsel can provide some additional clarification. And then the written waiver itself is no bar because the court never apprised on the record whether my client understood the contents of that written waiver. Yes, ma'am.
Thank you. I understand that we're both aware that this claim was not raised below, right? So there's an issue maybe with preservation of the issue. But just turning to the merits, why isn't it enough that the court, in this case where it was an assault, and unlike the case that you're quoting, the 2023 case, the Calderon case, where I understand this court did vacate based upon the failure to state on the record, but that was an attempted burglary. This is an assault particular case where there was reference to the assault of the victim. There was indication that this was going to be in favor of the victim of that assault, and that you were to stay away from, not you, but your client was to stay away from the victim of that assault. Why isn't that enough? I mean, is there a specific litany that colloquy that was supposed to happen to meet that statutory?
I think something beyond, the pro forma allegations in the penal law. The court has to justify its reasons, and just sort of the coincidence that prior information has been mentioned on the record does not necessarily mean that that's the basis for it. We could sort of in hindsight piece together something that we might be able to assume are the reasons that the court would have given, but the mandate is for the court to provide its reasons for issuing the order of protection. So I don't think just because certain facts that we might consider relevant would provide that basis. I think the court has to state that. And again, like I said, because this is a case where it was an assault, but it does not seem like the kind of facts that an order of protection contemplate the protection for, where he has no idea who this person in fact is. Going to the preservation argument for a moment, we believe that the preservation is not required here because this is an issue of a statutory mandate, and following the reasoning in the court's of appeals decision in Rudolph, that preservation would not be required for such a statutory mandate.
Thank you.
Good afternoon, Your Honors. Jonathan Sklar for the people. May it please the court. Your Honors, defendant's claim is barred here because it's unpreserved, and the Court of Appeals in Nieves bars these claims when they're not preserved. It's barred by his appellate waiver under People v. Rivera and People v. Gonzalez of this court. And three, it's totally meritless because under Gonzalez, it's perfectly obvious here why the court issued an order of protection where defendant assaulted the pizza delivery guy because he didn't bring him his pizza in the manner in which he wanted him to. Defendant obviously knows where he works, his place of employment, part a subject of the order of protection. So despite what my adversary says, he can easily find the victim again if he wanted to.
Counsel, the order of protection was issued at arraignments, correct? And then extended?
Correct. There was a temporary order of protection.
Did defense counsel or defendant ever object to the extension of the temporary order of protection?
It's not clear from the record whether there was an objection to the temporary order of protection, but there certainly wasn't to the permanent order of protection. And then just finally, or a couple more things, the Justice Michaels and Justice Rodriguez both stated the reason for the order of protection, right? The function of the order of protection is also the reason for its existence. That's not a meaningless tautology. That is just perfect logic. So the reason is to keep him away, defendant away from the victim. And then finally, if your honors are persuaded by my adversary's arguments, the remedy here is to remand, not to vacate, right? The Nieves sets forth that the trial court is the lower court is the proper forum for these kinds of vacature motions, and the victim has not had a chance to weigh in here about maintaining the order of protection. For all those reasons, we ask you to affirm. Thank you.
Thank you. Counsel, you have 1 minute.
I just want to touch briefly on Nieves. So Nieves is a case that precedes Rudolph by about 10 years. The reasoning rejected in Nieves was that the illegal sentence exception to preservation did not apply to an order of protection. That's not something we've raised here. And so it's our position that Rudolph is a far more applicable and on-point Court of Appeals decision. It's more recent. It applies directly to the statutory obligation that this court has, and that every decision of this court that I am aware of and that my adversary cited rely on Nieves, which we believe is not as applicable as Rudolph. So we ask that you vacate this. Just lastly, the vacature is obviously, as Your Honor mentioned, in this court vacated in Calderon just recently. It's an appropriate remedy. Thank you.
In Calderon, didn't they agree to the vacatur? Wasn't there a consent to the didn't they concede that the vacatur was warranted in that particular case, as opposed to this case where they don't agree?
Certainly, but it's only raised for the purpose that it's an appropriate remedy should the court decide.
All right, thank you. Thank you both. The next case for argument is Century 21.
May it please the court, may I begin?
Yes, please.
Your Honors, this is a insurance coverage case.
First, counsel, just tell us who you are and who you represent.
I'm
please.
sorry, Judge.
That's okay.
My name is Dennis D'Antonio. I'm with the law firm of Wegg & Myers, and I represent the appellants, including Century 21 department stores.
Okay.
Your Honor, this is an insurance coverage case. The policy in question has a variety of different coverage provisions. The one that's particularly relevant to the issue on appeal is found at record on appeal page 857, and it's the civil authority coverage grant. Before I read the grant to you, it's very short, but it's very important. I just want to point out that this is what's called a manuscripted insurance policy. It's not typical of the type of insurance policies that exist in every other COVID-19 case that's been decided, which are off-the-shelf, stock, standard language policies. This was a policy ensuring Century 21 multiple dozens of buildings, 14 department stores, a premium of, I think, $1.4 million. And when a policyholder has that kind of leverage, that they're paying that kind of premium, they sit down with the carrier and they negotiate terms. They deviated from what the standard form provisions are. So the lower court's reliance on the hundreds of cases that have been decided that physical loss or damage is a predicate for civil authority is completely misplaced because...
Let me ask you, how does this case, how would you distinguish this case from our case last year, since you say there's differences, with the Consolidated Restaurant Operations versus Westport Insurance Corp., which case is going to be argued up in the Court of Appeals in a couple months?
Right. Judge Kaplan, I'm glad you asked that question. It's getting exactly to the point I was at. The civil authority provision in the manuscripted policy contains the following words. The policy is extended to include business interruption loss for a period of 60 days. I'm paraphrasing, but now I'm getting to the quote. As a result of a direct physical loss, I'm sorry, reading the wrong clause. As a result of a peril not otherwise excluded, access to the vicinity is restricted by order of civil authority. And then here are the words. Regardless of whether any property insured by this policy shall have been damaged. You don't have that language in any of the cases, including Consolidated. This was language that was negotiated into this clause so that if Century 21 department stores had to be shut down because of a restricted access in the vicinity of Lower Manhattan where the World Trade Center was, which is where Century 21 was at one time, it was explicitly limited and eliminated the requirement that there be physical loss or damage to the insured property. And there's no policy language to the contrary, and there's no other case that's been decided throughout.
Counsel,
Yes.
that particular part of it, is that the part where the $5 million
No.
comes into play, or is that something separate?
That's something separate. I'm glad you asked that, Judge Pittsburgh. The underlying decision by the motion judge incorrectly states that every coverage granted this policy requires physical loss or damage as a predicate to coverage. And that decision is incorrect, partly because of what I just read to you from the civil authority clause, which explicitly eliminates that requirement, but also, Judge Pittsburgh, to your point, there's a separate provision, extension of coverage in the policy, which is the murder, suicide, infectious, contagious disease endorsement that provides coverage, and that doesn't require physical loss or damage either. That only requires that there be one of those events within 2 miles of the store. So the premise for the lower court's decision that there is a predicate requirement of physical loss or damage for there to even be coverage under the policy is belied by the language in the civil authority clause, which eliminates that. It's also belied by the murder, suicide, infectious disease coverage, which they paid, and that's under a separate coverage grant. It doesn't cross the Rubicon into what is civil authority coverage. That's a separate coverage grant.
I'd like to go back
Yes,
to
Judge Kennedy.
actually the Stetson real estate case as well as the Visconti case, because I know you're relying on the civil authority provision, but those cases indicate that that provision applies when there's an order of civil authority that prohibits access to the insured premises based on direct physical loss to property nearby. So when I look at your complaint, there's no allegations about damage to a nearby property or even damage to your property.
That's a wonderful point, Judge Kennedy.
Thank you.
Yeah, okay. Because it gives me the opportunity to explain something I wanted to explain. This particular policy doesn't have that requirement. If you read the lower court's decision, the lower court says just that provisions in civil authority frequently require this type of physical loss or damage. This policy doesn't require that. And at page 154 of the record on this case is the Allianz Insurance Company policy. We have not sued Allianz because Allianz used a different language than the STAR policy. And the Allianz policy has exactly the language that Your Honor is referring to. In the Allianz policy, it says for civil authority coverage to be in force, there must be physical loss or damage off the premises to excluded property, and then that would trigger your physical loss or damage coverage. That language is found in the Allianz policy. We're not here on the Allianz policy. The STAR indemnity policies that negotiated a manuscripted form eliminated that language, and that's why, Your Honor, with respect to the cases that do make that finding, they're distinguishable because they're policies that contain the standard civil authority coverage requirement.
Just one more, just one more thing before you sit down. So then it's your position that we would not need to wait for the Court of Appeals to rule on the consolidated case in order to reach your issues?
Absolutely correct, 100%. I've got an entirely different set of facts here because I have a different policy that doesn't have the predicate language that consolidated and other cases will have to address. It's as plain as day.
Also, and in the clause that you read, the word peril, is that defined anywhere in here?
No, it's not, Judge. And also keep in mind, it says a peril not otherwise excluded. There's an exclusion section in the policy that has exclusions. So if there is a civil authority loss that's predicated on a nuclear attack or a war or any of the other enumerated excluded perils, then there's no coverage, irrespective of physical loss or damage. And so it's not to be confused with our case because there is no exclusion for virus or pandemic or COVID-19. So we have coverage under civil authority for any restricted access that impacts us, except if it's caused by an excluded peril, and it's not in this case. And the arguments that the carriers have made to the judge below are all based on language that's not found in these policies, and the judge below completely misapprehended that this is a manuscripted policy. So when he wrote in his decision, there are hundreds of cases who have all uniformly said this, and that's what he's relying upon.
But the language here is
Misapply.
different according to you. Okay, let's hear from the respondents, and then you'll have some time to respond. Thank you.
Good afternoon, Your Honors. Matthew Burke on behalf of the respondent insurers from Robinson and Cole. May it please the court. Your Honor, this case is on all fours with this court's decision in consolidated restaurant operations, and that is because the civil authority clause in the policies does require a risk of physical loss or damage in order for there to be coverage. Your Honor asked about whether the term peril was defined in the policy. In fact, it is. There is an insured perils section of the policy that defines the coverage as all risk of physical loss of or damage to the property hereunder. And the civil authority clause provides coverage where, as a result of a peril, not otherwise excluded, access to the vicinity is restricted by order of civil authority. And so we have a peril requirement in the civil authority clause, and we have a definition of perils that defines it as all risk of physical loss or damage. And so therefore, based on those two provisions, there is a requirement that there be a risk of physical loss or damage. And that is what this court decided in consolidated restaurants, which is that the presence of COVID and the civil authority orders that go with COVID are not risks of physical loss or damage.
Well, given that that case, as I indicated before, is and leave was granted, and that case is going to be argued in the Court of Appeals, do you think we ought to wait to see what the Court of Appeals has to say before we make our decision?
Given the way the issue has been presented to this court, Your Honor, I would say no, because the way the issue, as you just heard, has been presented to the court is simply a very simple, straightforward issue. Does the civil authority provision require a risk of physical loss or damage? If the answer to that question is yes, based on the way the appeal has been presented, the trial court's decision should be affirmed.
Counsel, I understand your argument, but how do you reconcile what you just said with the last clause there, which says, regardless of whether any property insured by this policy shall have been damaged?
Your Honor, the way civil authority coverage works is not a direct impact on the property that gives rise to the coverage. In fact, if that were the case, it would be no different than business interruption coverage. The impact on the property is the order of civil authority. And that order of civil authority arises from a risk of physical loss or damage. And so there's no requirement that the property itself be damaged. In fact, the clause here doesn't even reference the property. It references the vicinity of the property. But the damage is not to the property itself. Civil authority coverage can arise due to damage to other property. So there may be property down the street where there's a fire and the city has to close the street, and therefore Century 21 store is not accessible. The vicinity is restricted. No damage to the property, but there is civil authority coverage. There can also be civil authority coverage when there's no physical loss or damage at all. If you have a hurricane approaching the city and there's an evacuation order and the Century 21 store is closed, but the hurricane goes elsewhere, there's no physical loss or damage, but there is an order of civil authority that impacts that property. The point of that regardless clause is that there does not need to be physical damage to the property insured. There does have to be a threat or a risk of physical loss or damage in order to give rise to the civil authority clause, but it's the order of civil authority that impacts the property, not property damage. As long as that civil authority order arises from a risk of physical loss or damage, then there can be coverage. The regardless clause is simply to identify that the property itself does not need to be damaged. Now,
Counsel, so if we interpret it the way that you're interpreting it, that means consolidated restaurants on all four.
I'm sorry,
that means that consolidated restaurant is on all four?
It is, yes, sure. No question.
So shouldn't we wait for the Court of Appeals?
That is certainly up to the panel to decide on that issue. But the issue that's been presented to the court is not that issue. The issue that's been presented to the court is there a risk of physical loss or damage requirement in the civil authority?
It's really a contract interpretation, right?
Yes. And one last point, Your Honors. The murder-suicide infectious contagious disease provision, that is an extension of coverage for circumstances that clearly are not a risk of physical loss or damage: murder, suicide, disease. The fact that they had to add an extension.
And that was paid, and that's not...
That was paid. There's a $5 million supplement paid at the outset of the claim before any litigation was filed. If those circumstances were covered, i.e. in the absence of physical loss or damage, there would be no need for the extension. But there is an extension because there is a risk of physical loss or damage requirement for the other provisions, including civil authority. And the language of that extension itself says all other, it reads, all other terms and conditions remain unchanged. So a specific coverage with a $5 million sublimit was created to give coverage for things that don't arise from a risk of physical loss or damage. All of the other policy provisions remained intact, including the civil authority clause, for which there is a risk of physical loss or damage requirement. And that is what's missing here, and that's why the trial court decided as it did. And we would ask that the panel affirm those decisions. Thank you.
Thank you.
Good afternoon. May it please the court. My name is Joanna Young. I am representing Respondents Access Surplus Insurance Company. We have adopted the arguments that Mr. Burke has presented so eloquently, so I will not repeat those. I'm just here to address that Access also believes that there are two exclusions in the policy that would also preclude coverage here. I won't belabor that, but with respect to the pollution and contamination exclusion, which specifically includes virus, the appellants have relied upon a decision from the District Court in Nevada that was recently vacated in September by the Supreme Court of Nevada. So I just wanted to point that out to the court. We have submitted that supplemental authority for your consideration.
That's why we do sometimes wait for the highest courts in the country. Yes.
Yes.
Yeah,
And so unless the court has questions, I'm happy to rely on our brief and give our time back.
Okay.
Thank you.
Thank you. Appreciate that.
Your Honor, first of all, there's a definition section in this policy that's found at Record on Appeal page 865. There is no definition.
It's not in there.
It's not in there,
So
Perils.
I wanted to, before I forget, go back to something that the attorney from Robinson and Cole said. I'm sorry, I don't remember your name, but he indicated that there would not have been a need for that extension portion that was paid if the interpretation was as you thought it was. So how do you address that?
They're separate events. I mean, one is just if there's murder, suicide, infectious, contagious disease within 2 miles that the insured could argue diminish their sales. There would be coverage. There need not be any orders of civil authority or anything else to trigger that. So it's not the same coverage. Also, counsel pointed out that's an extension of coverage. Well, the civil authority provision, the beginning words are coverage is extended. That's also an extension of coverage, the civil authority provision. And as to the point he's making that the policy has a perils definition, it reads, perils insured and territory, all risks of physical loss or damage to the property hereunder while in all situations. The property hereunder is the same property that the civil authority says it's not necessary for there to be damage to the property insured. They're the exact same provisions, and in one instance, it reads the way I read it, but the civil authority provision then carves out only under civil authority, not under other clauses, that you don't need physical loss or damage. And the best case scenario, what you're left with, is an ambiguity. And it's axiomatic in New York if there are contradictory clauses, which if you accept their argument, you have contradictory clauses. I don't think they're contradictory. I think that there's a carve-out on civil authority that doesn't require physical loss or damage. I think it's unambiguous. But if you would accept their argument, all you have is an ambiguity because you have 2 policy clauses saying 2 different things, and the only way the motion court could grant the motion to dismiss is if they ignore the language in the civil authority provision that exempts it from requiring physical loss or damage. And if you read the lower court's decision, he doesn't even mention it. He does not mention that civil authority language is there. He doesn't try to rationalize or explain how it is he's concluded that physical loss or damage is a predicate for civil authority. He just cites all the other New York cases. So this is not a case that's on point with Consolidated. It's entirely separate and distinct. All you have to do is look at the policy language. The insured purchased the policy. They carved out physical loss or damage for civil authority. My claim is for civil authority. It's covered. There are also clauses in the policy that say if there are any inconsistencies between printed and typed forms govern, and there's also a clause in the policy that says that the intent of the parties is supposed to be enforced under the policy terms and conditions. The only way that the motion was granted to dismiss on the pleadings was to absolutely ignore the language in the civil authority grant of coverage that exempted it from the physical loss or damage. This case should go to trial. This case should go back to the court. There should be discovery, depositions, and let it be decided on the merits rather than a motion on the pleadings. Thank you, Your Honors. I'm sorry I ran over.
That's okay. All right, thank you. Thank you all very much. The next case for argument is Hassin versus Hassin.
Good afternoon, Your Honors, and may it please the Court. I'm Michael Ansell of Next Gen Counsel on behalf of the appellants and objectants Stephen and Jacqueline Hassin. Now, the respondent uses the fact that the Hassin family engaged in a decades-long and unlawful tax evasion scheme to obfuscate the true ownership of the funds held in Swiss bank accounts as the shield by which they seek to prevent the beneficiaries of the estate of one of the true owners from getting title to that property. Now, the respondent's going to rely heavily
I thought
on...
their position was that the decedent didn't have any interest because he didn't contribute any money to the Swiss bank account because he didn't have any interest in the business that funded it.
Thank you, Your Honor. And so that point is a red herring because it's undisputed that as of the 1980s, and in fact, through 2005, the decedent was actually an account holder on accounts that held these assets. So although we believe there's ample evidence in the record to demonstrate that the decedent was in fact involved with the business, an owner of the business at the time it was formed and at the time it took in these significant revenue in the 1980s, that is essentially besides the point because it's undisputed that after that time, he had been made an account holder of these funds. And I think what we really have to address here is the tax records, right? That is the glaring, most easily identifiable issue here that demonstrates the decedent's ownership. So this family went through what's called the Offshore Voluntary Disclosure Program to repatriate and identify assets that had previously been hidden from the IRS. The decedent was part of that. As part of that process, the family was required to file foreign bank account reporting statements, the FBARs, as well as amend and...
Didn't the expert say that there's a difference between having a financial interest and being an owner?
Yes, Your Honor. So in order to file an FBAR, you have to have well, there's two parts to an FBAR, right?
So a person could have a financial interest without being an owner?
Yes. So the FBARs require, under Part 3, which is what the decedent, the respondent, and their sister filed under, that's for joint owners, right, of foreign bank accounts. Now, the IRS specifically defines what a financial interest is. There's 4 types of financial interest that can exist, right? And so the respondent tries to obfuscate here by just claiming this, that there's some separate thing called a financial interest. That's not the case. A financial interest is either ownership through direct title, ownership through nominee title, 50% ownership of a corporation holding title, and 50% beneficial interest in a trust holding title. Now, through the course of this litigation, the respondent's position was that there was some long-standing family trust going back to the 1960s in Switzerland when the great-grandfather was forced to flee Egypt. At trial, they abandoned that, right? So throughout litigation, it was the financial interest was that as a beneficiary of a trust. That was abandoned at trial because there was no evidence of a pre-existing trust. In fact, there's no evidence or record of any indication of a trust existing prior to the decedent's death, at which point the respondent came up with this trust concept. So the experts agreed that looking at the evidence and at the FBARs, the only type of interest that could have been held was ownership through nominee title. In fact, the IRS issued a closing agreement. The decedent's closing agreement was signed by the respondent. That closing agreement says, decedent controlled and/or was a beneficial owner of offshore entities holding the Pictet account. Offshore entities purport to be entities separate and apart from decedent. Decedent treated the assets and financial accounts of the offshore entities as his personal assets and accounts at all times. The assets held in the name of the offshore entities are assets of decedent. Every tax record here indicates that the decedent was a true beneficial owner of 30% of the assets held in the Swiss bank accounts. Now, at trial, the new excuse from the respondent was, well, the IRS told me to lie on those tax forms because my grandfather was ill, they didn't want him involved. So the family was represented by Baker and McKenzie in US tax. Apparently, the IRS told the respondent alone, just himself, to lie on their tax returns. One would think someone should have gotten that in writing. But that's besides the point because the trial court excluded that from the evidence, finding it to be inadmissible hearsay correctly. And so there's absolutely no evidence in the record to indicate that the tax returns are anything but truthful. And the record is also quite clear that the entire purpose of the OVD process is to identify assets previously unreported overseas. And so that is what happened, and every tax document in this case evidences the decedent being a beneficial owner of 30% of the Swiss assets.
Okay, let's hear from your adversary, and you'll have a few minutes to respond. Thank you, counsel.
Thank you, Your Honors.
May it please the court, Tom Brown of Maria Schwartz, Bradham, Friedman, and Brown on behalf of the respondent, Samuel Assine. I want to start where Mr. Ansel began, which is the idea that this massive tax fraud, tax evasion scheme, simply not the case. The evidence is very clear that the whole reason the Hassines hid the money in Switzerland was because of the horrific experience they had when they were expelled from Egypt, the assets were seized, and they were forced to flee in the 50s. And they hid the assets, but the effect of them hiding it was actually to pay more tax. They paid tax when they earned the money, they deposited in Switzerland, and then as they brought it back into the US, they paid tax as if it were income, even though most of it was principal on which tax had already been paid. So it's not a tax evasion scheme. It was fearful people hiding money because of the persecution the family had endured before. And the bank records are clear. The decedent had no relationship with Bank Pictet, which held the assets for over a year before he died, and his relationship with UBS, which held them until 2008, terminated in 2005. Even when he was on the accounts from 96 to 2005, there was no right of survivorship under the account documents.
Counsel, were there any tax returns that were produced, that were signed by Samuel that indicate that David was a 30% owner of the Swiss bank accounts?
No, Your Honor, there are not. There are some tax returns in which 30% of the income that was brought into the US was reported on David's return as income, not the principal, not the assets in Switzerland. And recall that Baker McKenzie and US Tax considered reporting 100% of the income under Fred's name. And then they didn't report anything under Fred. Instead, they went with this 50, 30, 20 split because that's what they were directed to do by the IRS. And the simple fact is the IRS didn't care who owned what. If you look at what the IRS did, how they dealt with this, they treated it as a single pot of money. They imposed one penalty on Sam, $8 million. The entire family paid this penalty through him. It wasn't 50, 30, 20. It wasn't David, you're 30% owner, you got to pay 30% of the penalty. It was treated as a single pot of money that the IRS didn't care who really owned. And one of the key features here is the appellants themselves admitted
What in the record shows that the IRS doesn't care who owns what, which doesn't seem to me to be the way I usually understand that, but where in the record can I look?
The fact, Your Honor, that the IRS imposed a single penalty on the whole corpus shows they treated it as a single pot of money, it's not a 50% penalty paid by Sam and a 20% penalty paid by Lillian or a 30% penalty paid by David. The IRS treated it as a single pot of money on which a single penalty was paid. And the appellants here themselves agreed in 2010 in the family agreement that it was a single pot of money managed by Sam. We addressed that strongly in our briefing. It's not mentioned in the reply at all because there's no explanation for it. In order to be a nominee, you have to have money that you put into other people's names to hide it. David didn't make this money. It has been conceded repeatedly by the appellants. It was in a joint statement of undisputed facts that they attempted to vacate. The court denied their attempt. They haven't even appealed that, which means that's the law of the case. And so you have a situation where the money was treated as a single pot. The appellants concede that their father had nothing to do with generating it. And once he was taken off, he was never made any attempt to get back on. And if it's a grand tax scheme, why was only David taken off? Why was David the only one who held it through a nominee? It simply doesn't make sense. The account documents show no ownership, and the F-bars do not show ownership. They're trying to hang their entire case on testimony by Mr. Springsteen, who changed his entire theory on the eve of trial. His entire story collapsed on cross-examination. He was found by the court below not to be a credible or believable witness, which is a finding of credibility to which this court should defer because the judge below sat through his testimony amongst the 11 days of trial. And you can't take this expert's interpretation of these documents and find ownership where all of the documents themselves that define who owns the bank accounts don't give any ownership to this decedent. The other fatal flaw with the claim is they're supposed to show you
The Lillian testified, and maybe there was something else in the record that said that this money was basically a family pot. It was like a nest egg for the whole family. So if that's how it was used. I think it was more than just her testimony. So does that have any weight? What weight does that have, of any, in figuring this out?
It's significant, Your Honor, because under their theory, Lillian owns 20% of this asset. And she's not a party here. And she specifically disclaimed her own ownership.
Is there anything, but she doesn't own anything? Is that what you're saying?
She has testified unequivocally.
She's in the same position as, I know David's passed, but she also had, there was no 20% ownership to her either, so.
No, she testified, and specifically, she disclaimed any ownership. She said none of us ever owned it individually. If they're right, she owns 20% of this to their 30%. And she specifically disclaimed any ownership. The other fatal flaw with their claim is they're supposed to show what's missing with some certainty. They have no idea how much money it is. They can't give you a number. They didn't give a number to the court below, and they can't give you a number. So their level of proof is simply flawed. And the well-reasoned decision of the court below should be affirmed. Thank you, Your Honor.
Thank you.
What's telling here is...
So, counsel, in this case, you have the burden, right? You have the burden to show that your objections had some basis to them, and
Yes, so we have the initial burden. It is a burden-shifting analysis.
Right.
And I would, and that's one of the legal flaws, I think, in the court's reasoning, is that the tax records themselves should have shifted the burden to the respondent to demonstrate, right? Again, what we didn't hear from counsel is what was decedent's financial interest that was disclosed in these F-bars, if not as an owner through nominees. Again, we hear the IRS told them to lie, the IRS does. That's not in the record. It's preposterous for one thing, but it's not in the record. It's been expressly excluded by the trial court. So there's no evidence about what the IRS did or didn't tell them. It's undisputed that the decedent's tax records disclosed a financial interest in these foreign assets, that the experts agree, based on the tax documents, the only one that would be an option is ownership through nominee title, right? Now, we show through credible testimony that in 2005, the respondent with his son flew to Switzerland, removed the decedent as an account holder, added the son and nieces and nephews as signatories to the account for the purpose of, quote, safekeeping David's assets, because David was potentially about to marry a woman in New York, and the family had prior experience with these assets in a divorce through Lillian's divorce. So it was a way that respondent was removed him from the account in 2005 because of this potential marriage. Now, it's also undisputed that the decedent's access to and ability to get these funds remained unchanged, right? The respondent admits that. He could have gone, he just had to ask somebody, but he got it. So his status, even though he was removed as account holder in name, was unchanged. And so we agree. If he had been listed as an account holder, we probably wouldn't be here, right? That's the central issue. Now, from a legal standpoint, the tax documents, which are entitled to judicial estoppel effect, right, was enough to shift the burden back to respondent. Here, the court found that the appellants didn't even satisfy that initial burden. And so we've also shown that there's a myriad of other evidence about the ownership. He had access to these funds even after 2005, paid for apartments, paid for private tuition in universities for his children. There's really no dispute about that. And the courts have made clear that just title to the accounts themselves is not determinative, right? So in Ray McLaughlin's estate, 265 NYS 332 at 334, Surrogates Court, New York, they look to a number of different types of evidence, right? Different factors regarding what the intent of the parties was with the bank accounts, not just whether or not the person's name is on them. Thank you, Your Honors.
Well, thank you both. The next case for argument is Frid versus McDonald. Good afternoon.
Good afternoon, Your Honors. May it please the court. My name is Jacques Simon. I represent the appellant in this case. This case presents a lot of issues, but as I was forming my argument, I wanted to frame it, and I was asking, how would I start that? And I start by the question that Judge Engoron asked of me. You got a subpoena, the father complains, let's keep it simple. He used the word simple. Give the records to them. That's how he started all this. The court below does not believe that a Fourth Amendment, that's the premises to the underlying case, exists. That comment in and unto itself demonstrates that the court does not believe that the appellant has the right to challenge the subpoena. And then from then on, the court ran afoul every possible case in New York that governs the law regarding the investigations conducted by the Department of Health. And somehow that law has been lost over the years. And somehow it's been overridden by different holdings of the appellate division, including this appellant division, but didn't really address what the Court of Appeals initially said, that the Department of Health, that the OPMC has to do in order to issue a subpoena. And the procedure that they have to follow in order to issue the subpoena, before they issue the subpoena, and before the wheels of the investigation start turning, that's the language from Levin versus Muraski in the Court of Appeals. The court below also did not follow basic tenets of what the Department of Health has to do in order to show that they're entitled to an ex parte review of the documents. Not everything is...
Specifically, what is it that you're saying that wasn't shown? What was needed to be shown?
They have to show Levin versus Muraski and Sussman. They have to show that the investigation is delicate and that, and I'm going to give the example in a second, and that something disclosing the nature of the complaint is going to endanger their investigation. Now, if we go back to Muraski and to Sussman, Muraski relied on Sussman. Sussman was a criminal investigation of the organized crime in New York. So the Attorney General argued, if we tell them what the investigation is about, the criminals are going to obliterate the records.
Counsel,
Yes.
I just maybe need you to focus your argument just a little bit for me, because I feel like I've lost you somewhere along the line. Are you saying that when these kind of things are being investigated, or if there's some sort of issue with a doctor, that it should be made public, or it should be confidential as the public health law indicates?
Two different issues. Thank you, Judge. There is the public, and then there's the doctor. Two different things. The issues are not made public to the public. And I cited in my reply brief the exact case that followed the Court of Appeals cases. And there was a case in this jurisdiction also. It was Howard Robbins versus New York City Office of Chief Medical Examiner.
But aren't the facts in this in the situation here very similar to a case where I see you also represented the appellant in the matter of Horowitz? I mean,
Right here.
Yes,
Right
I
here.
read that. So, I mean, didn't the judge? Didn't our court find that it was proper for the court to do an in-camera inspection of these of the documents before they made a determination whether the subpoena should be complied with? And we found that the court correctly denied the petitioner's request for declaratory relief and injunction, which you were asking for here. So I don't see how this is any different than what was decided.
That case was totally different, Judge, and I'll tell you what the facts and why it is that it was different. In that case, there was not a divorce where the mother comes in and tells the OPMC that there is no bona fide basis for the investigation.
But I don't see the divorce being, I mean, that's just a factual difference with this situation. I don't see that a basic difference.
The judge in that case, I did not raise the issues that I'm raising before this panel in Horowitz. In Horowitz, I asked for discovery under Rule 403, I believe. And then I argued in Horowitz that the necessity of knowing what the complaint was about in that case is important. And I cited it wasn't the same case law as it applies here, and not the same part of the Moraski and the Sussman cases. That case did not involve any of the issues before this court.
The fact that the mother alleged to OPMC that the father's bringing this because he wants some leverage, that doesn't negate OPMC's responsibility to investigate, does it?
I totally agree, Judge. That's not what I said in my papers. What I said in my papers is talk to the mother. Number one. Number two, they are saying in their papers, on such and such date, such and such, or according to the OPMC, such and such conduct or treatment occurred, and my daughter was hurt. Now, I'm going to give you this example because I'll tell you how this simplifies everything. It used to be when the OPMC investigated these matters back at the beginning of 2000s, they would say, we received the complaint, and here are the issues. They did not used to disclose the identity of the complainant. The reason for that was simple. It was compliance with the Moraski rule. So what the doctor would do would come back and say, okay, I have the records right here, and here are the issues, and here's my response. Don't simplify everything right there. What was lost in the process is that now they're asking for an entire medical record to expand their investigation beyond what the issues in the complaint are.
Let's stop there.
Yes.
The issues in the complaint, and you talk about Moransky. So isn't the bottom line is that, you know, when we're at the investigatory stage, right, we're really looking to see the allegations, you know, are they authentic? And let's talk about that, right? Because you have the complaint,
right?
Allegations of misdiagnosis, administering treatment, not medically indicated, resulting in infections, and the interview by, you know, the complainant.
There's no record of that interview.
I'm sorry?
There is no record of the interview. There's no record of there's no record of anything, and there's an exclusion of the appellant from the entire process. We can't tell that there was a record of the interview. We can't tell what the issues are to address it with the judge and tell him that these are non-issues. We can't bring witnesses at the beginning, which is what Moraski asked, and show them that there is no bona fide basis for the investigation. There's nothing for us to see. Nothing. You may see it, the judge may see it, we get excluded from the process 7804E and 7804F get obliterated when Public Law 230 confidentialities are used as a shield and as a hiding place for the OPM.
Well, let me ask you, because maybe, let me just, wouldn't that be an issue for you to take up maybe with the legislature? Because like these laws are written in a certain way. There's a confidentiality for a reason. The investigations proceed for a certain reason in the purview of the public health law and OPMC. I'll just leave it.
Okay, and there is a procedure that the Court of Appeals prescribe when such issues arise. And the procedure is not to exclude the litigant from the process. And that exact process that the Court of Appeals said in Murawski and Sussman was followed by this court and by New York State Supreme Court in Howard Robbins versus Office of Chief Medical Examiner that I cited in my reply brief. So you can't really have two standards for different agencies. In one, the medical examiner's autopsy, which is much more significant than an investigation by the OPMC, it's confidential. What the judge did in the case of Howard Robbins, she sealed the documents, just like Sussman said, but she didn't exclude us from the litigation. We saw it, we addressed it with this court, we addressed it to the court below, and I lost fair and square.
Okay, counsel, let's hear from your adversary, and you'll have a few minutes in rebuttal. Thank you.
Good afternoon, Your Honors. Dennis Fan on behalf of the state respondents. I just want to start with a question that Justice Kapnick asked, which is whether this is on all fours with Horowitz, and we think it really is. Horowitz addressed something very specific. It addressed whether information in a complaint that was filed with OPMC should be kept confidential, because under the public health law, there's a very specific confidentiality provision for complaints, and also there's another one for the files of OPMC. So both of those would protect information that comes from a complaint and then information that is developed from that complaint. Your Honor asked about the interview report. OPMC here did interview the complainant. That's how they got to the authenticity of this particular complaint. It wasn't a process where they just, found a document out there in the world and decided to investigate a particular doctor. That distinguishes this from Murawski and this Sussman case. I mean, Sussman is not even a public health law case, but Murawski, what it says is there are general principles out there that allow courts to keep things under in-camera review and to permit the in-camera process. But if you look at that footnote in Murawski, what it doesn't cite is it doesn't cite the specific statutory provisions of complaints in the files of OPMC. And that's why over the decades, opposing...
It seems like your adversary is complaining that they're being kept in the dark, but it seems like those statutory provisions that you're citing, that's what it does.
Yeah, I mean, I think that's right, Your Honor. They're being kept in the dark for a very good reason. If you're routinely telling the target of a subpoena why you want the subpoena, exactly what information you're looking for, and remember here we're talking...
You're concerned that they could destroy or somehow change the records. I mean, that's one of the concerns that you indicated in your papers.
I think there's at least 3 or 4 different confidentiality reasons, right? One is destroying records, one is protecting minor children, as we have here, and having their information disclosed without any particular reason. Another is protecting the complainant themselves. You have complainants who might be harassed, who might be blamed for things, who might have their, as here, motives impugned for having brought forward complaints to begin with. And beyond that, I mean, you want to protect the doctors. I mean, there's been all sorts of cases. We cite this case, Anonymous v. Board for Professional Medical Care, and there it was a doctor bringing an Article 78 challenge against the board and against OPMC and saying, look, you disclosed information about me and about the complaints that were against me. That impugns my reputation and my good name, and I don't want that information out there in the world. So that's why these legislative enactments are so protective about this subset of information. And the cases of Murawski and Sussman just don't address those specific statutory provisions. Instead, what we have is Horowitz, which does address this particular provision. And I will say, it's not like OPMC didn't give them any information. We submitted a public affidavit. We told them that there was an investigation happening. We told them very high level what the substance of that investigation was, which is that we're here about mistreatment of this and misdiagnoses of this particular patient. And so they have, at a high level of generality, the ability to then say, look, that's actually not even an authentic type of complaint. That's
Also,
a totally
was the
frivolous
petitioner's
complaint.
Fourth Amendment rights violated?
No, Your Honor. I think for two reasons. One is I think Horowitz dealt with that issue very, very specifically. And the second is, the Fourth Amendment, I don't think it's any more protective than what we have here in New York, at least with regard to administrative subpoenas, which is to show some authority, some amount of relevancy.
You don't even need probable cause, do you?
Yeah, I think that's right. The Fourth Amendment has a higher sort of probable cause threshold. But in that sense, I don't think their rights were at all violated. And instead, what we did is the court below allowed them to argue why the subpoena shouldn't be issued. It allowed them to even argue against the fact of in-camera review. And so they had all the sort of procedural and constitutional protections you would want to have in place before implementing this sort of process. Unless Your Honors have further questions, this court should affirm.
Thank you.
I'd like to address the concerns that the OPNC raised here. Identity of the complainant, not an issue. We know who the complainant is. An assumption that the complainant is going to be harassed, they haven't made the showing. In, I believe it was Atkins versus Guest. They made the showing that in there, the doctor said that he needed the complaints to go and sue whoever made the complaint. They haven't made that showing here. There's no concern of harassing the complainant here. The protection of the minor child, we know who the minor child is, and we refer to them by initials. Protecting the complainant against, again, not an issue. And then there is something that they want to protect the doctor, but the doctor doesn't need protection because she's the one bringing these particular proceedings. So really, using this case really focuses on A, revisiting Horowitz and taking a long look at it in the light of Murawski and Sussman, and B, due process. There's a long line of cases that I cited in my brief that excluding the litigant from an Article 78 proceeding and participation in an Article 78 proceeding is a due process violation. Apparently, Judge Crane in Howard Robbins versus Acme knew that. So instead of excluding the litigant from participation in the Article 78 proceeding, she did exactly what Sussman said.
But isn't this more appropriately a CPL Law 2304 proceeding?
I'm sorry?
Shouldn't this have been a CPL Law 2304 proceeding?
No, because challenging a subpoena is in my briefs. Challenging the subpoena, the proper vehicle is an Article 78 proceeding.
Okay, we'll certainly take a look at all this. Thank you for the arguments this afternoon.
Thank you.
The next case for argument is Gilbane versus Fort Hill Construction.
Good afternoon, Your Honors. Jonathan Cohn from Rex Whitehorn and Associates for Defendant Appellants. My defendant appellant's argument is simple in this matter. It comes down to the burden and the process for summary judgment motions and the trial court's review of same. There are a slew of cases all saying that summary judgment is a drastic remedy, that if there's a tribal issue of fact, the relief of summary judgment should be denied. That's to afford the side that...
What's the tribal issue effect that still remains?
The tribal issue of fact is in this contractual matter that the court had before it, that the court only considered the statutory aspect, but not the actual contract itself and the provisions in that. The trial court was given 4 subcontracts for 4 different properties in this matter. And if this court looks at R30 to 31, R61, R96, and R119-120, the court will see that there's a clause 3.9, a paragraph 3.9, that provides that if a genuine claim has been raised by one side, that will not be considered a material breach of contract. So in this matter, what was raised was that Gilbane, the plaintiff respondent in this matter, had not paid the defendant appellants money, that the defendant appellants properly put in the demands to be paid for work already done, so that they could use that money.
Well, let me ask you this question about that demand for paid work that was already done. Was that in the form of the invoice, or was there something more? And is there a requirement that there should be something more under the statute?
Well, there was a demand that was made, and that was put through a computer system. I don't have the name of it, but it's in my papers. It was entered into that. Gilbane acknowledged receipt of it. But what the court's asking is, does the statute take the place of the contractual clause? And I researched the matter, and I cannot find anything that says the statute, the New York Prompt Payment Act, takes the place of any contractual provision that also deals with
Also,
the
is there a
issue.
contractual provision that allows the respondent to stop work because they weren't paid?
Yes, because the
Where is
3.9 says that if there's a genuine claim.
That doesn't say anything about abandoning work.
No, but it could encapsulate it, and we assert that it did encapsulate it, and we assert that
Isn't that writing
argument.
something into the contract that's not there? Because if the intention was that you're not paid, you're permitted to abandon and jump ship, would have said that.
Your Honor, respectfully, I disagree. The reason is there's also no statement of what the term genuine claim is. So does that automatically throw out every claim that's made from the contractor to the other side? I would argue no, because then what is the purpose of having that language in there? In this matter, they had, if there's a genuine claim.
Yeah, but by stopping work, you in essence gave yourself a remedy.
By stopping work, we were saying, pay us. We demanded payment. We put in a genuine claim. You haven't made payment.
Well, you say you put in a genuine claim. What was the genuine claim?
Were the invoices that are.
So you just put in the invoices, they weren't paid. Did you do anything else after that?
I believe there was contact back and forth.
Were you required to give any sort of notice that, well, if you're not paid within a certain time, then work would stop? Were you required to do that?
Not that I saw in the contract.
What about pursuant to the statute?
If we were solely relying on the statute, then the other side has a point. There was no evidence.
So it's your position that the contract overrides the requirement of the statute? Or it does away with it, it's not necessary?
I'm not saying that it overrides it. I'm saying that it supplements and adds to it. I'm saying that the statute allows for a safe harbor under the statute, that if you do X, Y, and Z, including a notification, that's one element of the X, Y, and Z to get this safe harbor under the statute. What I'm saying is that the contract supplemented and said, if you have a genuine claim, then you do not have a material breach. And the documents in the record, and 337 to 451, which were submitted to the trial court, the contracts at the record on appeal.
But why wouldn't it be required, in order for you to have a genuine claim, which is what you're asserting, why wouldn't that mean that you would have to comply with the statute? Why doesn't it mean that? Right? In order to, you would have a genuine claim if you had sent notice, pay us. If you don't pay us by this date, then we're walking off. Why isn't that the general claim? Because now it complies with the
Because
statute.
there's no definition for genuine claim. But I would put to this court that a genuine claim in terms of millions of dollars owed to a contractor arises to a genuine claim. That if it was a 50-cent invoice, that would not be a genuine claim. That the court has to take a look at the realities of construction and how parties contract with one another to come to what the court considers its definition of genuine claim.
Okay, let's hear from your adversary, and you'll have a few minutes on
Thank you.
rebuttal. Thank you, counsel.
May it please the court. My name is Mark Snyder. I'm a senior counsel with Picard and Abramson, PC.
Well, counsel, let me ask you this same question because, I mean, people who work jobs, they expect to be paid. And if they're not paid, why would they continue working that job? Why is that not their genuine claim?
Your Honor, because the phrase genuine claim has nothing to do with why they were terminated. If you look at the record, there are 4 notices of termination that Gilbane served on Fort Hill, all of which went unresponded to. And they list a litany of problems with Fort Hill, with the quality of their work, with their failure to show up on the job sites, with their failure to respond to the notices of default, with the failure to respond to their requests for adequate assurances, the failure to pay their concrete suppliers. There's dozens of reasons why they were terminated. Not one of them was because they asked to be paid for work that they had done. Furthermore, my adversary began this by talking about burdens of proof and why we should be reversed below. The trial court specifically found that Gilbane met its prima facie burden. It established that there were 4 subcontracts. It established through 4 very lengthy affidavits with exhibits annexed thereto that Fort Hill had materially breached each of the 4 subcontracts. And while liability was only at issue on the summary judgment motion, those 4 material breaches also clearly caused Gilbane significant damages.
And the bottom line is that you sent 2 separate 48-hour notices of material breaches, an opportunity to cure, both in December of 2017, and both were ignored.
That's correct, Your Honor. Yes, 1 was sent on each of the 4 projects at issue.
So can't the Supreme Court granted you summary judgment on the issue of liability. So the issue of damages still has to be tried, correct?
Yes, Your Honor.
So these claims that defendants alleging is that, well, we did a lot of work that we didn't get paid for. He allowed to bring that up in the damage phase of the case?
Foreseeably, I would imagine they would present it as some sort of an offset. But as we noted in the papers, the affidavit submitted by Martin McKernan, the principal of Fort Hill, does not set forth how you can use those pieces of paper to calculate their damages. They don't show how much has been paid against any of those documents. They don't say when they were submitted. They don't say how much or when they became due. I mean, they don't even meet their burden to say that there is a dispute of fact.
So the damages you were suing for, damages for what you had to pay to get the work completed that had not been completed by defendant?
That's correct, yes. Yes. And what's more, this issue of the material dispute, it's a complete red herring. On the underlying motion, the opposition submitted by Fort Hill, the appellant here, flat out said, we acknowledge that we walked off the job. We acknowledge that we stopped paying our people. We acknowledge that we couldn't get anyone to show up. However, we had the right to do that under the Prompt Payment Act. Now, what they don't allege is that they met the prerequisites of the Prompt Payment Act, which does give you the opportunity to walk off the job if you provide the general contractor and the project owner 10 days written notice of your intent to suspend work because you were unpaid.
And they never did that?
Never.
And
They don't
there's
even.
nothing in the record that they rely upon that says they did that?
Your Honor, they don't even make the allegation in the record, and that's specifically what the Supreme Court found. It wasn't that the documents weren't, sufficient or that there was a credibility determination, or she overlooked a
There
disputed
was just
fact.
nothing.
They don't even allege that they complied. And that was their defense. Gilbane didn't make that argument up. That was what they had said. And the reason that they had done that, and the reason they don't make that allegation, is because they didn't do it. Now, this argument was contrived 4 years after the fact. If they were really concerned about non-payment, if they couldn't perform because of non-payment, there would have been email after email, there would have been text messages, there would have been letters sent back. When Gilbane said, Fort Hill, we need to know that you guys are coming back here. We need to know that you're going to return to the project. We're asking specifically for adequate assurances that you're going to complete your scope of work. If Fort Hill didn't come because they weren't being paid, they should have responded at that point in time and said, well, if you pay us, we'll come back. They didn't do that. Their opposition that they walked off under the Prompt Payment Act was completely contrived. The Supreme Court properly found that Gilbane met its prima facie burden and that Fort Hill failed to rebut that presumption. Thank you.
Okay, thank you, counsel.
And just some quick rebuttal. While opposing counsel properly brings up that I cannot testify as to facts or documents not in the record, opposing counsel should not be able to do so either. And this is the issue. The issue is opposing counsel did bring up that the court rendered that there's a prima facie case. Defendant appellants are not disputing that there's a prima facie case. They're not saying that they went back to work and they were working and et cetera. However, the trial court did have a tribal issue of fact in the contractual provision that the trial court did not consider, did not acknowledge, did not deal with, and opposing counsel, the movement on the motion for summary judgment, did not dispel that tribal issue of fact with any actual affidavit, document, anything except for an attorney affirmation. And that's it. Thank you, Your Honors.
Thank you. Thank you both. The next case for argument is People versus Eustace James, and Justice Rodriguez is also recused from that case. Good afternoon.
Good afternoon, Naila Siddiqui for Appellant Eustace James. A sentence of 20 years for a 19-year-old with no prior contacts with the criminal legal system, a significant mental health history, and a case where the co-defendant charged with the same exact crimes and received only 7 years is unduly harsh. Again, we're not condoning or defending Mr. James's behavior. We do understand.
Mr. James was the person who actually stabbed the individual?
Yes, so the theory at which the prosecution proceeded was charging Mr. James and his co-defendant with murder in the second degree as well as felony murder. There's allegations that there was a robbery where the co-defendant was with the decedent. Initially, Mr. James was not nearby, and based on statements between the co-defendant as well as Mr. James, when the fight started, Mr. James came in, and it was one stab wound that did unfortunately result in a very tragic incident where the co-defendant did die. But again, Mr. James was 19 years old at the time. Courts have acknowledged that youth. He also had a significant mental health history, including schizophrenia, bipolar, psychosis, paranoia, hallucinations, had a history of hospitalizations, both at Bronx, Lebanon, and St. Vincent's. Given his mental health history.
Were those things that the trial court was aware of when they were
So this was, it was listed in the pre-sentencing report. This was an offer made by the prosecution, so the trial court did not have any authority to give anything less than the 20-year sentence that was a negotiated plea, which is why we're asking this court to reduce the sentence as unduly harsh. It is, the second department and the first department has reduced sentences in manslaughter cases that were less than 20, both in Crump. This court reduced Man 1, given that the co-defendant received a significantly lower sentence. And in the second department, in People v. Dillon and People v. Green, courts there reduced a 17-year sentence to 12 and 18-year sentence to 10. So we're asking this court to exercise its interest of justice jurisdiction to reduce Mr. James's sentence. He was 19 at the time of the offense, and he received a 20-year sentence. With respect to I will now move on to the appeal waiver.
I just want to go back, if I may, because you keep on saying 19 years old, but the person that he killed was 17, a week or two before high school graduation. The co-defendant attempted to rob him, and when the decedent either, refused or tried to protect himself, no threat, defendant stabs him once, kills him, right?
Well, so in terms of what actually happened, the statements that he joined in when there was a fight happening between teens, I do understand that the decedent was 17 years old. They were all teenagers. The co-defendant received YO as well as a 7-year sentence for all the behavior where they all knew each other. So I'm not trying to, this was a tragic incident. However, 20 years for a teenager with significant mental health history is unduly harsh. The co-defendant was
also. What is it
also.
that you're asking us to reduce it to then? What would be fair for this 17-year-old's death?
Well, I think 20 is very harsh. I think, obviously the co-defendant received 7. Considering the tragic nature and the circumstances, a sentence between reducing it to 14 years, I don't think is unreasonable, given that courts have reduced manslaughter sentence where a person did die, given the circumstances. This is about, rehabilitation as well as longer studies have shown, and it's consistent with neurobiological studies that courts are currently addressing, legislatures are also addressing with Raise the Age, where youth is a mitigating factor for culpability. Again, this was a tragic incident. No one is saying that it wasn't. However, given that longer sentences do not support the idea that for rehabilitation, so this is why we're asking for the sentence.
I just want to go back. Yep. What happened a year later, after? Was there any other activity that happened after?
So Mr. James, so the incident happened. Mr. James was not arrested at the time. A year later, he did engage in a robbery that involved a BB gun. He was sentenced and pled guilty for that.
An elderly gentleman, correct?
Yes, I believe so, yeah. And it was
Did something happened in prison? What happened in prison?
He was 20 years old at the time, had mental health issues. We all have read about the horrors of being on Rikers Island, so considering he was 20 years old at the time, significant mental health illness, he did engage, he was arrested for assaulting an officer. I will just note that, it was assault in the second degree with arguably misdemeanor charges, and the worth of those, the court already considered, he pled guilty to all of those. He has admitted his guilt in all of those, was sentenced to sentences to all of those, and it was just this sentence that was for 20 years. And again, this is consistent with youth and mental health issues where normally the robbery and the assault, aside from the manslaughter, would have or could have been dealt with alternatives and interventions where courts are now looking to.
Was there anything in the record submitted to support, other than his claims of his mental health issues, was there anything else provided to the court at the time?
It's not, my understanding there wasn't. So this was a negotiated plea with the prosecutor, so again, it wasn't up to the court.
Was it presented to the prosecutor?
I don't have a record of, I don't have a record of what was presented to, I just have the court file. So again, the court this is not an offer by a court, it was an offer made by the prosecution. The court did not have the authority to undercut it, so even if it was presented to the court could not have reduced the sentence.
Okay, thank you. We hear from your people.
May it please the court, Amir Kedmati for the people, the respondent. Good afternoon, Your Honors. Your Honors, at the outset, I'd like to say that the defendant waived his right to appeal. he entered a valid waiver. He signed 3 waiver documents. There were no issues with the oral colloquy. The lower court adequately separated his trial rights and his appellate rights. But to the extent that this court has interests of justice jurisdiction, I'll just say a few words about the underlying conduct. Defendant is minimizing from the fact that he went on a spree of crime for about for a stretch of 2 years. He was convicted of 3 violent felonies. One of them involved the killing of a 17-year-old boy, as the court pointed out. He was just a recent high school grad, was on his way to pick up ice cream, and he was robbed by defendant and his accomplice. To the extent that defendant today is now raising allegations of, or in their brief, allegations of self-defense, defendant waived the right to, he renounced all of the self-defense or any other argument in defense of these allegations in the indictment, as it was articulated and confirmed by the defendant at plea and sentencing and his counsel. Lastly, I'll just say that, as the court pointed out, a year after he killed a 17-year-old boy, he robbed an elderly man on his way to visit his 90-year-old mother. This time, the only lesson he learned from the first incident was he not only took a knife with him, he also carried a BB gun that pointed at the victim. And it was a very convincing-looking gun. After that incident, he was arrested, and a year later, he assaulted a correction officer.
Now, was it true that for the crimes that he was charged with, he faced an aggregate sentence of 47 years to life?
That is correct, Your Honor. The sentence exposure that he was facing was 47 years to life. And in fact, had he gone to trial and been convicted of murder in the 2nd degree, he would have been facing 25 years to life. So at the minimum, he was facing an indeterminate de facto life sentence. But here he received a 20-year determinate sentence with 5 years of post-release supervision. And in light of the totality of his conduct, this is a very, very good offer that his counsel was able to negotiate. And lastly, I'll say, as far as all these allegations of psychological and mental health disorders, they are completely uncorroborated in the record.
They weren't in the pre-sentence?
They were in the pre-sentence report, Your Honor, but there is no, they're all stated by the defendant in that interview. There is no other
You have no
evidence.
medical records to back that up?
None whatsoever, Your Honor. Unless Your Honors have any further questions, I'll rest on my brief and ask the court to affirm.
Thank you.
Thank you, Your Honors.
Just very quickly to address the waiver issue, the lower court has an independent obligation to properly explain what an appeal waiver entails. Again, this is Mr. James's first contact, first time ever taking a plea. He dropped out of high school, and it is our position that the waiver was invalid and does not bar this court from reducing the sentence. Mr. James was only told that the right exists and it's being waived, and had he exercised the right, a lawyer would be appointed. With respect to any theoretical max that he could have faced, the court and the prosecutor had him plead guilty to the robbery as well as the assault too, giving him the minimum sentence, which was the court's ability to do so. And so that should have no bearing. Obviously, had he been offered the maximum, he would have gone to trial on those cases. But here he was given a choice where he pled guilty to a death occurring where he stabbed someone without the intent to actually kill, which is likely what happened. And for those reasons, we're asking this court to use its interest of justice jurisdiction to reduce this sentence, given that he was 19 years old at the time.
Thank you. Thank you both. Salmasiros versus New York City Department of Buildings. Good afternoon.
Good afternoon, Your Honors. Daniel Rabinowitz, Galina, and Rosen for Appellant Christos Samasiros. May it please the court. First, Correction Law Article 23A should protect individuals like appellant whose conduct led to a corporation's conviction, but then had the conduct used against him to support a denial of renewal of his licenses.
I mean, he is the sole shareholder and owner of this corporation, so it was his actions.
Exactly, it was completely his actions. This is supported by the denial by DOB of the license renewal. They stated that Mr. Samasiros engaged in a scheme involving the submission of falsified business records to the New York State Department of Taxation, and that he disclosed having been convicted or pleaded guilty to an offense.
But he himself did not plead guilty, right? It was like the corporation.
Yeah, so the point is that Mr. Samasiros, his actions, DOB alleges that his actions completely led to the conviction of the corporation of which he was the sole shareholder. Then they used those actions as part of denial of his renewal applications for sprinkler and plumbing licenses. But if he personally was convicted of actions and taking certain actions that DOB states resulted in the conviction, if he was actually convicted, Article 23A of the correction law would have prevented these actions from being used against him to deny licensure. So we're in a weird situation where if he was, he'd be better off in getting licenses from the Department of Buildings if he was actually convicted of a crime personally. But the fact that he wasn't convicted of any crime and only his corporation was for his actions makes it so that his actions can be used against him to deny renewal of licensure.
I mean, doesn't the City Department of Buildings have some kind of responsibility to make sure that the people that they allow to have these master plumber and master fire suppression licenses are trustworthy? I mean, shouldn't that be something they are concerned about? These are important licenses to take care of the people in the city of New York.
Yes, you're correct. The Department of Buildings does have this responsibility, and these licenses are important to ensure safety of individuals in the city. However, other cases of this court with similar circumstances, with holders of similar licenses, it was found that these actions like this involving actions like theft and defrauding the government, these are not sufficiently a risk to the public to support denial of licensure for posing a risk to the public. These cases are cited in the brief, for example, a lot of cases involve stationary engineer licenses, which involve keeping accurate records of boilers in the city.
I mean, weren't they concerned about the fact that he had submitted documents to a government agency that had false information on it? And a lot of these people that do this type of work and have these licenses do self-reporting to a government, to the government agency. And they're concerned about his moral character and his ability to give true information on these documents. Isn't that a reasonable thing for the city to be concerned
That is a reasonable thing for the city to be concerned about, but in numerous cases of this court, it found that, things involving fraud and entering into kickback schemes with government agencies or the Department of Education or the Board of Education.
For this same type of license?
These are stationary engineer licenses, which involve filing reports with the city of boilers and keeping accurate records of boilers for later submission to the city. In one case, this court, Enri Delaporte, 106 AD 3D 446, the individual held a stationary engineer license, was convicted of embezzling funds from the New York City Board of Education in a kickback scheme. The DOB denied renewal of his stationary engineer license, and this court reversed, and it found there was no danger to the public. Part of that was because the petitioner in that matter did jobs in between his conviction and denial of licensure and was not sanctioned by DOB in any way, and that's the same situation here. Appellant performed some 30 jobs in between the conviction of Bay Ridge and after the denial of the license renewal applications for his licenses, and he was not sanctioned by DOB in any way. And under all these licenses, his two licenses, one of which he earned in 1999 and one was issued in 2000, he performed over 2,600 jobs, pulled over 2,600 permits with DOB, was not sanctioned one time by DOB in any way. So the point is that we're not saying Mr. Samasiros is completely innocent. He admits what he did wrong. He admits that he hid income. But given the president of this court and all the other jobs he has worked under DOB issued licenses and has not been sanctioned once, the presidents of this court say that he should not be deemed a risk to the public through further licensure.
Okay, I will hear from the respondent, and we'll give you a couple minutes on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court, Ian Sinclair with the New York City Law Department for respondents, New York City Department of Buildings.
So is your action in this case arbitrary and capricious because you've permitted other people, as petitioner has indicated, to renew their licenses based on some of the same behavior?
Yes, so thank you for that question. The cases that Petitioner's Counsel focuses on, Delaporte, Donovan, Nuziel, Gill, Bovich, Jakubiak, all of those cases they focus on an entirely different legal issue, which is whether the Department of Buildings properly applied Section 752 and 753 of the correction law, not the broader question of whether they properly denied renewal under the standards for non-renewal set forth in the construction codes. That's really what this case is about. Whether the Department of Buildings rationally declined to renew Mr. Samosiros's master plumber, master fire suppression piping contractor licenses based on the grounds set forth in the construction codes. And the record...
Well, had he been convicted personally as opposed to the company?
Yep.
How would the correction law have affected your decision vis-a-vis the renewal?
Well, 2 points on that. One, the actual decision for non-renewal, if he had been personally convicted, would have been subject to a correction law analysis under Article 23A. And in that case, the Department of Buildings would have developed a record that analyzed Section 752 and 753. But that's not what happened. So we don't know exactly how the case would be different because there's no record that addresses that point. Footnote 4 of the department's final determination says expressly, we're not deciding under Article 23A because it's not applicable, because he was not convicted of a crime. So, and we think that Article 23A does not and should not apply because first, the plain text precludes it. As petitioner concedes, Section 751 of the correction law, which sets forth applicability, clearly states that it's limited to persons previously convicted of crimes, which Mr. Samosiros was not. And a plain text construction is consistent with past precedent. A few years ago, this court in Hodge declined to extend Article 23A to persons whose convictions occur during the term of the license or employment because the plain text requires that the conviction precede the license or employment. And so there's no reason to stray beyond the plain text in a case where the petitioner was not convicted nor even charged with a crime. And lastly, on that point, I'll just note that the general purpose of Article 23A is to eliminate the stigma of past convictions and to better facilitate re-entry into society. And again, that's not what's happening here. There's no irrational bias because the department's decision rationally determined that his conduct bears on the duties of his license, which are to, in addition to other things, honestly and lawfully manage a plumbing and sprinkler business. That is a core requirement of master plumbers and master fire suppression piping contractors that is distinct from their tradesperson counterparts. And yes, so if there are any more questions, I can yield my time.
Thank you very much.
Thank you. We ask the court to affirm.
Briefly first, in the cases cited in our briefing, the DOB took the same position that licensures should not have been renewed. And in each instance, this court forced DOB to overturn its decision and renew licenses. So DOB has taken this position in the past with similar conduct to that committed by Samosiros. It says that we cannot trust you with a license. And then this court said in numerous instances that, no, you can trust them with a license. Schemes related to kickbacks or fraud that don't involve actual work under the license, so not actually work involving plumbing or fire suppression work. As long as the conduct does not directly involve that work, it does not directly impact the public to deny licensure. Even if the correction law doesn't apply in this matter, which it should, because the only difference between Samosiros and anyone who's been convicted of a crime is just his status of a criminal conviction. It's still, the underlying conduct would be the same here as it is in other matters where people actually are convicted of a crime. Court-ordered license is renewed. So even if the correction law doesn't apply in analogous factual circumstances, the DOB ruled differently in this matter than what the outcome has been in different matters that were before this court. As to the fact that whether the correction law apply, because Mr. Samosiros was currently licensed, for example, in Henry Donovan cited 107 AD 3D 590, the stationary engineer license was first issued in 1996. The individual was convicted of stealing from the New York City Department of Education and defrauding it in 2008 and applied for license renewal in 2011. So this court has in numerous instances applied correction law to those currently licensed who commit some kind of criminal conduct during the course of holding the licenses. And as for the stigma of a criminal conviction, even if Mr. Samosiros doesn't have that stigma, he First, he disclosed his company, Bay Ridge's conviction. He wasn't even asked to by DLB directly. He was asked if he was personally convicted of a crime. He said yes, because his company was. And then DLB used the fact that he was criminally convicted to deny renewal of the licensure. So even if they're saying that it's not a stigma that he's convicted of a crime, in effect, it's the same thing in this matter. Bay Ridge was convicted of the crime, and the conduct that led to that crime is being tied to Mr. Samasiros personally to deny licensure.
Okay, thank you. Thank you both. Pereira versus KSK Construction.
Good afternoon. May it please the court. Patrick Lawless for the appellant, United Crane. KSK and Soho Broom are not entitled to contractual indemnification against United Crane for several reasons. Number one, the only valid and enforceable indemnification agreement in effect at the time of the accident was the 2015 agreement between Cooper Services and United Crane. That agreement contained a negligence trigger requiring a finding of negligence against United Crane in order for them to be required to indemnify anyone. It's undisputed that United Crane is not negligent and wasn't even at the premises at the time of this incident. And United Crane cannot be held liable for the purported negligence of its subcontractor, as that agreement does not require.
Isn't there also a rider in effect from 20?
It's not a rider to any agreement. There's a standalone document from 2019, and it's between KSK and United Crane.
Right.
And there's absolutely no consideration. That's not enforceable. This court has.
So you're saying this is not enforceable even though both sides signed it and?
Yeah, because there's no consideration. KSK didn't hire United Crane. Cooper Services did. There's no consideration. You have a statement by KSK that they wouldn't have permitted United Crane onto the premises.
Wasn't there that the Port Authority required more insurance coverage than you had? Did I make that up?
Well, that has nothing to do with the indemnification agreement or the lack thereof between.
That's why you needed it.
I'm sorry?
Isn't that why you needed this agreement?
It doesn't matter because the only thing that's been produced is a standalone document. It's not attached to any other agreement. There's no consideration. So under those circumstances, that 2019 agreement is not enforceable. It doesn't matter whether it's been signed. It doesn't matter what the testimony of United Crane's witness is, whether there's an expectation or not. There's no consideration for that agreement. It's not enforceable. All the other arguments made by KSK and Soho Broom also don't require indemnification. Again, there's nothing in the Cooper Services agreement that requires United Crane to indemnify for the negligence of its subcontractor. And the subcontractor, according to this court's own rulings, is not an employee. The fact that there may have been an acceptance of a tender by United Crane's insurer has nothing to do with the indemnification agreement. And there is no basis to enforce the 2019 agreement, again, because of the lack of consideration. Thank
Okay,
you.
let's hear what your adversaries have to say, and you'll have a chance to.
May it please the court, John Fabiani, Conan Hall, for respondent KSK Construction Company.
So can you
There are
can you address
206,000 reasons why there. 206,000 reasons. That's how much my client paid United Crane for this work. There has never been a case in the history of jurisprudence of this state of dealing with a contractual indemnification in a construction contract that requires separate consideration for the obligation or the agreement to defend, indemnify, and procure insurance. It is a standard provision in well, I don't want to say every, in most construction contracts, as was included in this one. And when it was realized the day before this project was supposed to, or this aspect of the project was supposed to begin, that there was nothing in writing, which, as this court well knows, insurance companies do require that there be a written contract, KSK went to United Crane and said, we need you to sign a written agreement to indemnify us in the event something goes wrong in this process, and that we are an additional insured under your insurance policy because you've already provided us with a certificate of insurance that says that we're an additional insured, but it's contingent upon there being a written contract. So here is the written contract. So we meet the requirements of your insurance company that there be a written contract, providing that you will procure insurance for us.
So isn't that a sufficient consideration for this indemnification agreement?
There's more, yes, that's sufficient consideration. And the notion that was raised in the reply brief, that by refusing to allow United Crane to start this work, we were somehow interfering with its contract with Copper Services, is ludicrous. No self-respecting general contractor will allow a subcontractor on site without having proper risk transfer protections, which is exactly what happened here. And Kim Smith of United Crane knew that. Kim Smith of United Crane knew that as early as January of 2019, 3 months before this tragic incident occurred. And the notion that it's not enforceable, I commend the court to page 2083 of the record, at which counsel for United Crane acknowledges that the agreement is enforceable, except it's only enforceable as to a claim by the Port Authority, which of course isn't what the agreement says. So unless the court has any further questions of me, I will turn the floor over to Ms. Solari.
Okay, thank you, counsel.
Good afternoon, and may it please the court. Lauren Solari on behalf of Soho Broom LLC, who's the owner and developer of the construction site in this case. It is patently clear from the record that Soho Broom is an indemnified party under the contracts. The rider unequivocally states that United Crane, as indemnitor, agrees that the terms of that document shall apply to both the KSK indemnities as well as to the owner of any real property.
You were the owner.
Correct.
So when has that ever been a good excuse for not providing insurance? Because it doesn't have your name, it just says owner.
Right.
That's your point.
Exactly. So that rider, that 2019 rider, clearly applies to Soho Broom as the owner. Also, of course, that rider was a condition precedent to United Crane being permitted to work at the job site, and most importantly, to get paid for its work at the job site. As set forth in the lower court's well-reasoned decision, Soho Broom, as the owner, is very much entitled to contractual indemnification. And not to detract from any of the great arguments made by Attorney Fabiani, I will rest on my brief.
Thank you.
You have this 2019 rider that stands alone, that's not attached to any other contract. There's no consideration. This court is consistent.
They just explained what happened.
What contract is he referring to? There's a contract between Cooper Services where it hires United Crane as a subcontractor. Where's a contract saying that KSK was hiring United Crane to perform anything, or that KSK was hiring United Crane as a contractor or a subcontractor at the site? There's none. And the Benitez decision, which cited in a brief, and another case that I argued an appeal on called Peranzo, and both those cases found without consideration where a party had a standalone rider, but they weren't the party that hired the indemnitor, that indemnification agreement was not valid without consideration. Thank you.
Okay, thank you. Thank you all. Have a good afternoon. People versus Reese. Good afternoon.
Good afternoon, Your Honors. My name is Maya Kwasi from Arnold and Porter Case Scholler on behalf of Appellant Mr. Menachries. May it please the Court. The Court erred by admitting a high volume of Molyneux evidence in this case without a proper legal basis. At this time, appellate court intervention means providing the necessary guardrails to prevent against 1, too many prior bad acts coming into evidence, and 2, such prior bad acts coming into evidence in unmitigated detail. This case,
Yeah, there were three prior bad acts that came in, correct?
Yes, sorry.
And your position is that none of them should have come in. Is that
Correct, right. And that's because, one, unusually in this case, each and every sought for prior bad act between the complainant and Mr. Reese was brought into evidence. That is unusual. For example, we see in People v. King, where the prosecution sought to admit 8 prior bad acts into evidence, only 2 were admitted into evidence.
I thought there was one prior bad act that wasn't admitted into evidence. There was actually a request for 4, and only 3 were allowed. Is that not correct?
That's correct. The one prior bad act that was not admitted into evidence was against a separate individual, the complainant's ex-wife from a previous marriage, and it occurred more than 10 years before in the 90s, and so certainly that fit into, that was a proper decision by the trial court to preclude that evidence, but it's our position that the trial court should have gone further to preclude these prior bad acts as well. In addition to all the prior bad acts being admitted into evidence, they are also admitted in unmitigated detail. For example, the complainant was able to testify and say that as to this—
Did the court issue any limited instructions to the jury in regards to this evidence?
Yes, the court did did issue limiting instructions. However, despite those limiting instructions telling the jury how not to use the propensity evidence, the trial court failed to instruct the jury how to use the trial court evidence. And actually, in People v. Telfar, which was just provided by the Court of Appeals today, which we provided, hopefully you received that opinion. The Court of Appeals notes that sort of at least references in dicta the use of not instructing in the factual part listing as a point of reference the fact that the jury was not instructed how to use the propensity evidence. So that, of course, I think is a relevant factor.
The evidence in this Telfar case is a little bit different than what we have here, right? That case involved guns, a gun being found in a flatbed truck, and then 2 prior incidents of knowledge of possession of a gun, and that's where they went to. This is a different kind of situation, right? This is a domestic violence case where the information that was let in went towards the background and the nature of the relationship. That's not necessarily what we have here from the Court of Appeals. So I understand, thank you for submitting those cases, but I would say that it's probably distinguishable based upon the facts that we're presented with today. How would you respond to that?
There's certainly factual differences between Telfar and this instant case. However, the court did reference, for example, in their harmless error analysis, they noted that just because there was sort of a reference, sort of like a split verdict as to the trial court dismissing certain charges and convicting of other charges, that alone was not dispositive of the harmless error issue. So we submit that case for your consideration as to the harmless error analysis in particular. But turning back to the reasons why the Molyneux evidence was admitted in this case, background in particular, it's not our position that, certainly that the jury should have had sort of no sense as to the nature of the relationship between the complainant and Mr. Reese. On the contrary, they heard quite a bit of testimony as to how the complainant and Mr. Reese related to each other. For example, the complainant testified that she felt she had to ask Mr. Reese's permission to breastfeed their shared child, that she felt she was walking on eggshells, that she felt she had to ask permission for friends to come over. These facts are not at issue on appeal. Instead,
those facts also don't necessarily go to intent, right? These instances may shed light for the jury with regards to the defendant's intent.
Well, the issue of intent can be inferred from the charged conduct, and so we submit at this time.
It could be inferred, but again, as my colleague pointed out, domestic violence cases are different, right? They involve a dynamic that most people don't understand or accept. So why isn't it why shouldn't the complaining witness in a domestic violence case have an opportunity to explain the background? In particular here, the incident here happened on July 7, 2017. There was an incident from July 4th, 2017 that could be fairly characterized as the argument started on the 4th and spilled over to the 7th, right? They were arguing about the same thing, same conduct. Why is that not relevant, especially to intent?
Well, the issue with that is specifically that, that the complainant is able to testify to the nature of their relationship without referring to the prior bad acts. And here specifically we have prior bad acts.
Appears to be the nature of their relationship.
Well, if the nature of the relationship is violence, that goes specifically to the issue of propensity. And so on trial was Mr. Reese's conduct for the specific...
That also goes to intent, and that's why there needs to be a balance, right? I mean, look, letting in prejudicial information, that's something that the trial court wants to prevent, but there has to be a balance. And the question is, was it unduly prejudicial?
Indeed, exactly. And so the issue specifically as to intent, as you inquired about, if I could have a moment to respond, is specifically not, it specifically goes to the fact that the charged conduct sufficiently shows that there was not a question as to Mr. Reese's intent, sort of, reaching out and strangling the victim. Certainly none of that behavior is excusable, but the prior bad acts therefore only show sort of the issue of propensity rather than illuminating the intent, given that the charged conduct speaks for itself. And so again, looking at the unmitigated detail, not just the volume, the fact that all the prior bad acts were admitted into evidence, but also the unmitigated detail, being able to say to the July 4th incident that there were, beautiful brass bells that the complainant, that Mr. Reese held in his hands and, swung on the complainant 3 to 4 times. The nature of the relationship and understanding intent and understanding lack of mistake and all the 4 sort of reasons why the Molyneux evidence was admitted could be understood without such significant unmitigated detail and without referring to each and every prior bad act between the complainant and Mr. Reese, as we saw in previous cases like People v. King, where there was more of a surgical hand taken.
Okay, thank you very much. We'll hear from the people, and you'll have a couple minutes on rebuttal.
Good afternoon, Your Honors. Emily Galt on behalf of the people. The trial court properly...
Also, the conduct of the 7th, doesn't that stand on its own?
The conduct of the crime.
7th, doesn't it stand on its own? Why do you need the other prior bad acts?
Your Honor, it does not. We need the other prior bad acts to explain the relationship of defendant and the victim.
But why don't those prior bad acts indicate, well, if they had arguments and issues before, but if he hit her before, he hit her again? Isn't that propensity?
That would be propensity, Your Honor, but that's not the situation here. These prior acts showed that it put the people's case into a believable context, and it provided the necessary background information, which...
See, the line here is so difficult to draw between whether it's admissible or whether it's permissible, or whether it's probative, or whether it's just too prejudicial. And how do we make that determination? I would think it's tough for the jury to make that distinction in their minds, hearing this testimony.
There is this balancing test, and these events here, they were more probative than they were prejudicial. All evidence presented against a defendant at its trial is supposed to be prejudicial, and Molyneux evidence is no different. And here, if the jury didn't hear about these prior incidents of abuse, it wouldn't have made sense that an argument relating to separating and co-parenting led to defendant strangling Maren Reese, threatening to paralyze her, and then destroying all of her electronics. There was a lot of probative value here. They all occurred within the same year. They related to moving in, moving out, childcare, and as one of your honors pointed out, the one incident occurred just 3 days prior to the crime. So that really completed the narrative to how these events occurred on the day of the crime. And without these incidents, Maren wouldn't have been able to provide a complete and accurate narrative.
So would you agree that if it was error to admit any one of these 3 statements, that harmless error does not apply?
that it wouldn't have been harmless?
That harmless error analysis does not apply, meaning it would require reversal.
No, there was overwhelming evidence here of defendant's guilt and the jury acquitted him of the top charges, which shows that the Molyneux evidence didn't overwhelm their fact-finding abilities. Here, the top charge defendant was convicted of was criminal mischief in the 3rd degree. There was evidence that of the iPhone and the iPad that defendant had snapped in half. Those were submitted to the jury, and the people just had to prove $250 threshold, which was proven very clearly. For criminal obstruction of breathing and 3rd degree assault, that was proved by Marin's testimony, even without the Molyneux evidence. So there was overwhelming evidence here of defendant's guilt. If your honors would like me to address the other points in the brief, I'd be happy to do so. And I did just actually want to make clear for the domestic violence expert, in the reply brief, it says that we're conceding that the expert testimony had no relevance to the charge conduct. We are not conceding that. I can discuss.
Well, what is the relevancy to the charge conduct?
So on the day of the charge conduct, when Marin called the police and reported the crime, she didn't report the full extent of it. She denied that defendant was violent. She denied being beaten by defendant while she was pregnant. She denied that the physical violence had an increase in frequency or severity over the past 6 months, when overall it took her 7 months and 3 prior incidents of abuse to report this to authorities. So she, on the day of the crime, she did not report the full extent. So the expert's testimony helped the jury understand why a victim might behave this way, not explain the full extent of it. And this court has held that this sort of expert testimony is proper, and the cycles of domestic violence is something beyond the knowledge of the average juror. So we're not conceding that. So if your honors have no other questions, we rely on our brief.
Thank you.
Thank you.
Your honors, in People v. King, for example, when the 2 prior bad acts were admitted into evidence, of the original 8 that the people sought to admit, they were admitted in as the prosecution in that case said in their oral argument, in a heavily sanitized, quote-unquote, manner. Specifically, the 2nd prior bad act, the jury was only able to hear that the prior bad act occurred. And so in this case, we have an issue of unmitigated detail, and that's not something that can be glossed over, and that's not something that the people have, in this case, sufficiently responded to. Further, the people brought up the issue of proportionality, saying that the jury would essentially, need to understand how an argument would lead to violence in this case. But notably, the cases that the people cited to reflect a significantly different set of circumstances as to reaching to violence. In Levasseur, we found a circumstance where the complainant in that case was sleeping and then attacked. In Robertson, we had in that case a circumstance where the complainant was answering a phone and then was attacked. In this case, and then of course the reference to People v. King, for the reasons that I stated before, was heavily sanitized and when they were admitted into evidence, and not all prior bad acts were admitted into evidence. And so in this case, we have a problem where we have a domestic dispute between the complainant and Mr. Reese, where the dissolution of their marriage, a question as to where they will live separately, who will be the custodial parent. These are the sorts of issues where certainly violence is not acceptable, but we can imagine, a jury can reasonably imagine that such a charged argument where, as we've understood, has occurred, has been occurring throughout that day, could reasonably lead to violence. This is not a question of disproportionality where she was answering a phone and then the complainant, struck her in a manner, of course, in those cases, also using weapons. We don't have weapons in this case.
I mean, I know you think none of these incidents should have gotten in, but how, did you have any comment about the court's limiting instructions? Did those help? I mean, as I said, I know that's not your position. You shouldn't. They shouldn't have gotten in. But in terms of, you could comment on the limiting instructions, did the judge do something to help to help that along?
Yes, so in terms of the limiting instructions, we have the problem of, yes, the jury was instructed to not use the evidence for propensity reasons, but they were not instructed as to how they could use it.
But you had said that before, so what do you think the judge could have done that he did not do?
short of not including any of
Yes,
the prior
right,
bad acts,
that's what
would be limiting the detail. I mean, again, we had, even for the second act, a reference, the complainant was able to testify that she had just given birth, she was still bleeding, and that Mr. Reese kicked her multiple times in the stomach and she had to cover her womb. I mean, these are the sorts of it's like highly inflammatory details that would distract a jury and lead them to no other conclusion but to convict Mr. Reese of something. And even we saw that the jury acquitted Mr. Reese of the most severe counts, but the Molyneux evidence could have been enough to tip the jury to say, well, he's a violent individual, we need to convict him of something. So these are the sorts of issues that as to why the Molyneux evidence should have been precluded.
Okay, thank you. Counsel, I understand that you are doing this on a pro bono basis.
That's correct.
So we want to thank you and thank the firm of Arnold and Porter K. Scholler for letting you do this work. You did a very good job, so did you. And thank you both for discussing all the issues. And have a nice afternoon.
Thank you very much. Thank you.
And last but not least, matter of 350 East 86th.
Good afternoon, Your Honors. Maya Petrocelli for Appellant 1645 First Ave LLC. May it please the Court, this appeal stems from an RPAPL 881 proceeding whereby respondent developer who owns 1643 First Avenue and 1647 First Avenue sought access in order to pursue demolition of their buildings and sought access to my client's building at 1645 First Avenue. This appeal seeks modification of the order and the resulting judgment in two respects. One, in terms of indemnification. The lower court adopted respondent developers' proposed language, which essentially limited the developer's indemnification obligations to the extent covered by insurance.
Now, am I correct? Did I read it correctly that when they originally put in the application, they had a more extensive indemnification provision, and that original document or license then ended up getting into that final order? Is that correct?
Exactly, Your Honor. Respondent developer essentially pulled a bait and switch. They had a...
But you submitted, I presume you submitted a counter order, but the judge chose to sign their order.
Exactly, Your Honor. And the limiting language is entirely inappropriate given the fundamental principles of RPAPL 881, which essentially says that, sure, developer has a right to develop their property, and if access to my client's property is needed, access is granted. However, to the extent that my client obtains no benefit from developers' work and has not requested access, then essentially my client should be completely protected and should not face any liability with respect to the access granted and the proposed temporary protections. This limited indemnification provision shifts the risk to my client, which is entirely inappropriate, and which arguably, given the bait and switch, the respondent developer knows.
So you're asking for the same language that was originally in the license? Is that the language that you requested in your proposed counter order?
No, Your Honor. The language being requested is in the original brief. It's set forth in the preliminary statement, and appellant would request that that language and the order be modified retroactively such that the indemnification obligations are clearly in place as of the date of the judgments, given that the demolition has largely been completed.
Yes. I'm aware of that. And also, did you want some additional fees? Was that the second thing that you were looking for?
Yes, Your Honor. Appellant is seeking reimbursement of legal and engineering fees. The general premise is that a neighboring property owner should not be forced to make a choice between either paying fees to review the proposed protection plans and the license agreement, or simply entering into a license agreement that may or may not protect our property. Here, the lower court completely ignored our application. Respondent developer did not oppose the application and instead makes their first argument in their briefs to this court claiming that access was refused. However, their procedural history is completely incorrect, and access was not refused. Pre-litigation, the plans were reviewed on a number of occasions, amended twice. The first time amended so that the plans did not show that my client's property was being demolished, which is referred to as a typographical error by respondent developer. The second time to include additional protections that our engineer requested.
Wasn't there some issue about requesting access through the backyard of one of the neighboring buildings, and you referred to the wrong building, the uptown instead of the downtown, or maybe I got that wrong, but
Yes.
that was the problem.
That was one of the problems. Regrettably, yes. In our pleadings, we confused 1645.
43 with 1647.
43 and 1647. However, respondent developer knew the entire time that there was an error. If you look at their own survey, it shows the door opening and the secondary means of egress that appellant was pointing to.
Counsel, to the extent that there was an error and that error may have caused some delay, is that an appropriate reason to deny all fees?
No, Your Honor, it's not. Ultimately, fees should be granted according to Pan Asia Estate v. 29 West 19 Condo unless access is refused. Here, access was not refused. There was numerous good faith negotiations, pre-litigation and post-litigation, and simply put, respondent developers' proposed plans were insufficient.
Okay.
Thank you, Your Honors.
Let's hear from the other side. You'll have a couple minutes for rebuttal if you need it. Thank you.
May it please the court, Henry Mash of Rifkin Radler, attorney for the petitioner. I have 3 points to make here. The first is about the professional fees. My client should not have to reimburse the respondent for the cost that it incurred to delay this project and to assert baseless counterclaims. I mean, that's essentially what they're asking reimbursement for. That's not what Section 881 was meant to do at all.
Well, shouldn't there have been some fees that they were permitted? Should the court have considered that? I mean, no fees at all. That's kind of unusual in our PAPL 881 procedure.
Well, but the facts here are very unusual, right? I mean, we have a situation where the respondent stonewalled negotiations for 4 months while we were pre-litigation. And that, the emails and the letters speak for themselves. I mean, the issues that they raised were absolutely trivial. They didn't get back to us. That forced us to start this petition in the first place. And then, when we started the petition, they brought up these other trivial property-specific conditions, which we were able to address in a matter of weeks. And our engineer said, why didn't you bring this up during the negotiations? No explanation. On top of that, then you have the counterclaims that they asserted that forced us to make 2 motions to dismiss them. One motion to dismiss and a full-blown summary judgment motion. So when you take all that and you put it together, Supreme Court had to balance all the interests and I think correctly arrived at the right conclusion.
Did the Supreme Court actually write in her, I don't think she did in her decision, that I considered this and I considered that as a result of which I gave you no fees, rather than just saying, I'm granting you the license with no fees?
Right, that's correct. The order really just talks about the license itself. And then there's a line that says, submit a proposed judgment so that I can determine what conditions are appropriate.
Right.
So the court hit the reset button. Both of you submit judgments. We submitted our own proposed judgment. The respondent submitted their proposed judgment, and the judge just signed ours.
Yours, and yours had no provision for any fees.
And it said it very explicitly. I mean,
Also, why was the indemnification that you submitted different from the proposed order?
Well, there's nothing in the record that explains why that change happened, but the reality is we're not bound by the initial license agreement that we included as an exhibit in the petition.
It's okay to include a really broad indemnification, but then when it gets to it, you're going to limit it to whatever the insurance coverage is.
Well, let's not forget that the circumstances changed dramatically, right? I mean, initially we start the petition, and then that was long before these baseless counterclaims were asserted that we had to spend resources to discredit.
Well, wouldn't that go to the fees and not to the indemnification?
It goes to the
They're kind of 2 different things.
I mean, it's all when you're looking
I get that you were mad at each other, and I get it, and so maybe that came out, and that's how it dealt with. But really, they are 2 very different issues.
But at the end of the day, it all goes into one pot, and Supreme Court has to balance all of those interests. And the reality is there's no case law saying that we are bound by the initial offer that we made in the negotiations about the conditions on the licensing agreement. That's not the law in this state, and then shouldn't become it after this case.
Okay.
I just have points to make very quickly. In terms of the building code violations, because that's also a unique provision that the respondent wants to put into this license agreement. They want to include a provision that says that we would be responsible for building code violations that result from our work. And that is really just a backdoor way of reviving the counterclaims that Supreme Court dismissed. Because what's really going to happen here is anytime they have a building code violation, they're going to wave it around and they're going to say, look, this was because of your project, and now you have to create some code-compliant alternative. And if you have any doubts about whether that's going to happen, you can look at page 267 of the record, because that's exactly what they asked for in their counterclaims. So it's our position that the building department is in the best position to decide whether violations have occurred and who should be responsible for them. There's absolutely no reason that should be injected into this license agreement. The building department is perfectly competent. They can decide which property owner is responsible. If there's a secondary means of egress, if it's being blocked, the building department is in the best situated to handle that issue and has no place here.
Okay, thank you. Counsel, any rebuttal?
Through pre-litigation and during litigation, developer had to amend their plans 3 times. Counsel claims for trivial matters. Well, the first amendment was to show that my client's property wasn't being demolished and it was only developer's property being demolished. I don't consider that trivial. The second time was in terms of tiebacks. The 2 properties on either side were going to be demolished. My client wanted to know how the tiebacks were going to be installed and what testing method was going to be used to make sure that the tiebacks were properly installed. Again, not a trivial matter. In terms of any delay, developer caused their own delay in many senses. They engaged in this clearly contentious license agreement negotiation. Then they transferred the property to a related entity in November of 2021, which meant that they had to amend the caption, which wasn't done until January 26th. So realistically, the errors in pleading.
Amending a caption is not such a big deal.
Right, but they transferred the property. So the caption had to be amended such that the correct property owner was granted the license agreement. My point is that there was no basis to deny or completely overlook the application for legal fees and professional fees. My client was entitled to have professionals, both legal and engineers, review the license agreement, engage in the Article 7, RPAPL 881, and try to protect itself. Thank you.
Okay. We'll certainly take a look. Thank you both very much for sticking out with us, and have a good evening.
You too.